Any bias that you know of? Hearing no answer. All right. I'm sorry?
No, I don't believe there's any
No.
on my end.
No bias here either.
All right, any disputes arising out of this competition must be reported in accordance with the competition rules. Teams, your compliance with time requirements will be considered in scoring individual performances. All right, and at this time, could the teams please introduce themselves?
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Helen Blake, and today, along with my co-counsel, we will be representing the people of Colorado in the case against Avery Becker. I will be conducting the direct examination of Kyle. For my co-counsel to introduce themselves.
Yes.
Thank you, Your Honor.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Bo Turnage, and today I'll be providing the direct examination of Detective Jordan Markowitz, the cross-examination of Avery Becker, and providing the prosecution's closing argument.
Hello, Your Honor, members of the jury and opposing counsel. My name is Jane Lockley, and today I will be conducting the direct examination of Alex Cifuentes, the cross-examination of Taylor Perkins, and delivering the opening statement. Permission for our witnesses to introduce themselves.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Ellie Wadsworth, and today I am Jordan Markowitz.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Audrey Gordon, and today I am Kyle Kuzak.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Mary Walker, and I am Alex Cifuentes.
The defense?
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Haley Karras, and I will be conducting the direct examination of Taylor Perkins, as well as the cross-examination of Kyle Kuzak.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Lily Mastrangelo, and I will be delivering the opening statement, conducting the direct examination of Professor Blake Van Owen, and conducting the cross-examination of Detective Markowitz. Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Caroline Tusek. I will be conducting the direct examination of Avery Becker, the cross-examination of Alex Fuentes, as well as giving the closing argument. Your Honor, at this time, may the defense witnesses now introduce themselves?
Yes, please.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Donna Shaw, and I am Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Connor Grant, and today I am Professor Blake Van Owen.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Chloe Els, and I am Avery Becker.
Thank you. All right, this time I'm going to swear in team members, gallery, scoring panelists, and witnesses. Usually I'd ask you to stand, but given the situation, stand or sit as you please. First of all, team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
All right, now witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Gallery members, including teacher and attorney coaches, family members, and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I'm going to assume that was a yes for anyone here. Scoring panelists, could you please raise your right hands? All right. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do, Your Honor.
Yes,
I do.
I do.
Fantastic. All right. Before we begin, are there any preliminary matters or housekeeping matters to attend to?
Yes, Your Honor, the prosecution has several preliminary matters. We first request permission for our attorneys to either sit or stand during direct and cross-examination, and we ask the same for defense.
Whatever you're more comfortable with. I think if you pick one, that's probably easier, but whichever one you prefer, it's totally fine.
Thank you, Your Honor. We request permission that the witnesses be deemed to be on the stand when seated and appearing virtually on the Zoom screen, and we ask the same for defense.
That seems fair to me. That's granted.
We request for the purposes of expediency that any exhibits admitted to the court, or admitted by the court, be deemed to have been constructively handed to the jury, published to the jury.
Perfect. That makes sense to me too. I'll be granted.
And finally, we also seek the court's permission to deem any exhibit that is shared by means of screen sharing to have been constructively handed to opposing counsel for the review, and we ask the same for defense.
Certainly. I think everyone's seen it, so as long as you kind of give them a heads up about what it's going to be, that should be totally fine. I've got no problem with that.
Thank you, Your Honor. The prosecution has no further preliminary matters.
Preliminary matters from the defense?
Yes, Your Honor, a few preliminary matters. Your Honor, we ask that the timekeepers are able to communicate using the Zoom chat feature as to avoid time discrepancies.
Sorry, that will be granted.
Yes, Your Honor. Your Honor, we also ask that we do acknowledge that the prosecution does have their pronouns in their name, but we do ask that all the witnesses put their pronouns into the chat, as if a witness who is not performing is off camera, just for the convenience sake, it's also in chat to refer to them.
Prosecution, do you have any issue with doing that?
No, Your Honor.
Then that will be fine.
Your Honor, I would also like to clarify that in terms of timekeeping, in accordance to Rule 5.6 of the mock trial rules, that timekeepers are only communicating the time posted in the Zoom chat feature, with the exception to the 10 seconds remaining when they are allowed to appear on camera.
That will be fine.
Yes, Your Honor. And now, Your Honor, we also, do you and the jury have a copy of the stipulated facts?
I do have a copy of that. Members of the jury, are you all good to go?
Yep.
Yes, Your Honor.
Perfect.
No further preliminary matters, Your Honor.
All right. Prosecution, are you ready to proceed with opening statement?
Yes, Your Honor. Ladies and gentlemen of the jury, on March 6th, 2020, the defendant, Avery Becker, was seen on Ring camera wearing a devil mask and entering the home of her mock trial coach, Mackenzie Brackman. Now, Avery had planned to enter the home of her coach that day and vandalize his property. However, what Avery didn't expect was that Brackman would be home that day, and that Brackman, aware of the attack on his home, armed himself against the intruder using a knife from his kitchen. Avery, shocked and panicked to see Brackman sitting in his kitchen, overtook him and gained control of the knife. The two struggled as Mackenzie Brackman fought for his life, and Avery Becker fought to end their long-lasting conflict. Finally, near the front door, Avery stabbed Mr. Brackman in the back, literally. Avery proceeded to exit the house and left her mock trial coach dying, face down on the floor. The laws of physics don't allow an immovable object and an unstoppable force to coexist. One must eventually give way to the other. If there were laws governing the dynamics of high school mock trial, the same thing would be true. A team can't succeed if one person is an immovable object and the other is an oppositional, unstoppable force. Here, a skilled public defender and beloved part-time mock trial coach, Mackenzie Brackman, was the immovable object. Brackman was a lawyer seeking to impart skills and motivate the next generation of would-be lawyers. But Brackman had his methods that led to success. Avery Becker, one of Brackman's more difficult mock trial students, was the unstoppable force. An irreverent young person with her own way of doing things, or rather, refusing to do things, Avery wanted no part of Mackenzie Brackman's preparation for trial, or even mock trial practices at all. Avery won awards, but was also demoted by Brackman for her unwillingness to be part of the team. Their dispute grew so heated that Avery vandalized Mr. Brackman's car. And then, Avery, fed up with her coach and seeking to regain what little pride she had left, went to Mr. Brackman's home to vandalize it too. Except, unfortunately for Avery, the immovable object, Mackenzie Brackman, happened to be home when Avery snuck in the back door. And before Avery Becker could leave, a physical altercation had broken out. That fight ended with a knife plunged in Mackenzie Brackman's back, and he died in a pool of blood in his front hallway because of Avery Becker. Today, the prosecution will call 3 witnesses to the stand. First, we will call Detective Jordan Markowitz, who will explain her findings on the crime scene, as well as the data collected from Avery's phone on the day of the crime, which proves through cell tower tracking that her phone was near Brackman's house on March 6th. Next, we will call Kyle Kuzak, a certified crime scene reconstruction investigator, who will describe to you the steps she took to reach her conclusion on the case. She will explain to you how the Ring camera footage from the day of the murder and the scuff marks in Brackman's home are evidence of a break-in and struggle that ultimately resulted in his murder. Finally, we will call Alex Cifuentes, who, previous to her crime, was great friends with Avery. Alex will relay to you the mutual loathing between Avery and Mr. Brackman. She will describe the level of disrespect and poor temper Avery had toward Mr. Brackman. Then, Alex will recall the night Avery vandalized Mr. Brackman's car. And finally, she will describe to you her text with Avery, in which Avery explains her plan to break into Brackman's home. Members of the jury, the evidence the prosecution will provide today overwhelmingly leads to the conclusion that Avery Becker, the unstoppable force, grew fed up with her mock trial coach, and in her attempt to vandalize her home, Avery violently turned to murder. At the conclusion of this case, the prosecution asks that you find the defendant guilty of 2 counts: murder in the 1st degree and 2nd-degree burglary of a dwelling. Thank you.
Great. Opening statement for the defense?
Yes, Your Honor. May it please the court?
When you're ready.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Lily Mastrangelo, and along with my co-counsel, Haley Karras and Caroline Tusak, we represent the defendant, Ms. Avery Becker. This is a case about carelessness and convenience that led to an erroneous conclusion. The prosecution rushed to come to a conclusion that is riddled with holes and that doesn't make sense. Throughout this trial, you'll hear how the prosecution consistently failed to follow clear leads and didn't even confirm Ms. Becker's solid alibi. The prosecution willingly overlooked evidence and alternate suspects. For instance, the prosecution failed to investigate Blair Rollins, a Colorado high school student whose father is in prison for life when Mr. Brackman was his attorney. Blair Rollins was also absent from school the day the crimes were committed and disappeared after graduation. This is merely one example of how the prosecution only gathered the evidence needed to make a quick and easy conclusion. The tunnel vision of the prosecution led them to a convenient conclusion rather than a correct one. What the evidence in this case will make clear is that Avery Becker couldn't have possibly committed the alleged crimes. The state's sloppy investigation led to an incorrect conclusion. And that is why the wrong person is sitting here on trial today. The defense will call 3 witnesses. First, Ms. Taylor Perkins, who is Ms. Becker's best friend and mock trial teammate. She will tell you about her observations of the relationship between Mr. Brackman and Ms. Becker. And with this, she'll tell you about fractures in this relationship. Ms. Perkins will then testify that she and Ms. Becker spent the evening of March 5th together, and more importantly, that the two of them spent the entire morning and afternoon of March 6th together. Ms. Perkins will testify that the prosecution didn't even check Ms. Perkins's phone to confirm her location on either of those days. This creates a gaping hole in the prosecution's case, as Ms. Perkins and Ms. Becker were together the entire day. So therefore, Ms. Becker couldn't have been in two places at one time. Next, you'll hear from expert witness Blake Van Owen, a private investigator and a professor who teaches police practices. He will take you through his evaluation of the investigation conducted by the prosecution. Professor Van Owen will tell you that this investigation was rushed, sloppy, and was blinded by tunnel vision. Professor Van Owen will testify to the three main problems in the prosecution's investigation. In his expert opinion, he will testify to 1, the uncertainty of the prosecution's claimed stabbing method, 2, the inaccuracy of the prosecution's cell tower diagrams, and 3, that overall, the prosecution's investigation was methodologically unsound. Professor Van Owen will show you through his thorough evaluation that the inadequacy of the prosecution resulted in a conclusion that is simply incorrect. And finally, you'll hear from the defendant, Ms. Avery Becker. Ms. Becker will tell you about her experience with mock trial and about her relationship with Mr. Brackman. And with this, Ms. Becker will tell you that this relationship had its difficulties. Ms. Becker will tell you about a prior incident with Mr. Brackman's car, about her regret over the incident, and about the great lengths she went to make amends with Mr. Brackman. Ms. Becker will then testify that on March 5th, she and Ms. Perkins went to the Fry Shack, where Ms. Becker lost her phone and didn't even realize it until the next day. Ms. Becker will then testify that on March 6th, she and Ms. Perkins spent the entire day together searching for that lost phone. And finally, Ms. Becker will tell you that she could never and she would never commit these crimes. At the end of this trial, we will show that the prosecution failed to meet their burden of proof beyond a reasonable doubt. The prosecution's investigation was careless from start to finish. Members of the jury, don't let the prosecution's desire for convenience and their utter disregard for accuracy put an innocent young woman in jail. At the end of this trial, the defense will ask that you find Miss Avery Becker not guilty. Thank you.
Thank you very much. Prosecution, are you ready to call your first witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand. Detective Markowitz, please introduce yourself to the jury.
Hello, my name is Detective Jordan Markowitz.
What is your profession?
I'm a detective with the Denver Police Department.
For how long have you been practicing in this field?
Well, I've been a detective for the past 7 years, but I've been working at the Denver Police Department for roughly 13 years.
Do you have any specialized skill sets in this field?
Yes, I have specialized training and experience with cell phones.
How were you trained to be able to use this skill set?
I had to pass a certification test and go through this training course through the American Academy of Law Enforcement. Through my training, I learned about the different types of cell phone data and records that can be obtained, how to use forensic software such as the Celebrite system to download the information from a cell phone, how to acquire and interpret cellular records, and how to obtain and interpret cell tower data.
And how does this skill set help you with your investigations?
Well, I use cell tower data on a regular basis. I've used it in over 50 cases, and I've downloaded the contents of literally hundreds of cell phones.
Your Honor, I tender Detective Jordan Markowitz as an expert in the fields of forensic cell data recovery and crime scene investigation.
Forensic, say that again for me?
Forensic cell data recovery and crime scene investigation.
All right. Any objection or voir dire?
No objection. Oh, no objection, Your Honor.
All right. Then she shall be tendered as an expert in forensic cell data recovery and crime scene investigation. You may continue.
Thank you, Your Honor. Detective Markowitz, how did you become involved in this case?
Yeah, so on March 6th of 2020, I got a phone call from first responders who found the victim, Mackenzie Brackman, deceased just inside the residence at 444 South Flower Street. Officers and I secured the scene at approximately 2:20 p.m.
Describe your first observations when you arrived at the crime scene.
When I first got there, I saw Brackman laying face down in a pool of what appeared to be blood. He was just inside the residence. You could see from outside the front door. There was a large knife near his body, a stab wound on his upper shoulder, and then I noticed a Ring doorbell on the outside of his house. I walked around the house where I found 2 more Ring doorbells, and I found that the side gate was unlatched and the back door was unlocked. When I walked through the back door into
Objection, Your Honor. Narrative.
Response, Your Honor.
Yes, you may.
Detective Markowitz is describing all of her observations when she arrived at the crime scene. To cut her short and not allow her to describe her observations would be to mislead the jury on how she formed her opinion.
Objection, Your Honor. Response, Your Honor.
Certainly.
Your Honor, the question asked was described your first observations of the scene, and the witness has gone far beyond their first observations of the scene.
Response, Your Honor.
No, that's all right. I'm going to say that I do believe the point of a narrative objection is to break it up. I think that's already been achieved. At this point, I am going to overrule at this time, noting that I think you're going to have to ask an additional question anyway.
Yes, Your Honor. Detective Markowitz, describe your observations once you went through the back door of the house.
Well, I found the house in a slight disarray. There was a knocked over chair and a broken plate, and the knife drawer was slightly open. The knife drawer had knives of different sizes and brands, and there was a empty knife slot in the knife block.
Explain the opinion you first formed with this new information.
Yeah, so the crime scene was consistent based on the other homicides I've investigated with a break-in where the victim caught an intruder in his home. After that confrontation with the intruder, it is clear that the victim went to the front door after being stabbed.
What was the next step you took in your investigation?
I downloaded the contents of Brackman's phone and watched the Ring videos. Then I retained copies of the videos for our files, making sure that they were in the same condition as when I found them.
What did you find when you downloaded the contents of Brackman's phone?
Found a tremendous number of emails and text messages related to something called mock trial. Brackman had also been found in a t-shirt related to mock trial, so it didn't take a lot of digging to find out that Brackman was the high school mock trial coach at Colorado High School.
What was the next step you took in your investigation regarding Brackman's time as the mock trial coach at Colorado High School?
Yeah, so I reached out to the members of the mock trial team and I got the contact information of all of those students.
And who was the first student that you reached out to?
I actually talked to Alex Cifuentes first.
And what was your interaction like with Alex Cifuentes?
Alex Cifuentes told me about Avery Becker.
Objection, Your Honor. Hearsay.
Response, Your Honor.
Yes, please.
This is not hearsay pursuant to Rule 801A because hearsay is classified as a verbal statement, written assertion, or nonverbal conduct. Detective Markowitz is simply characterizing her interaction with Alex Cifuentes. Thus, it is not
Response,
hearsay.
Your Honor.
Yes, response.
Your Honor, the witness testified, Alex Cifuentes told me about Avery, referring to an out-of-court statement in the past tense, which would be hearsay as it is an out-of-court statement.
Response, Your Honor. Response.
Yes.
Detective Markowitz did not testify that Alex Cifuentes told her anything specifically. Simply, Detective Markowitz was testifying as to the contents of her interaction with Alex Cifuentes.
At this time, I'm going to overrule. Note that she can talk about the general basics of the conversation. If any specific statements are elicited, please do re-raise your objection.
Yes, Your Honor.
Detective Markowitz, please finish your response on what your interaction was like with Alex Cifuentes.
Basically, she just told me about Avery Becker, our defendant here today, and her experience on the mock trial team.
And when did Alex Cifuentes tell you this information?
Oh, in an interview that I conducted with her and her parents.
Did Alex Cifuentes give you anything based on that interview?
Yes.
What did she give you?
She sent me a copy of text messages exchanged between her and Mrs. Becker.
Permission to show the witness what has previously been marked as Exhibit 14, Your Honor.
Yes, sorry.
Detective Markowitz, do you recognize this?
Yes.
Can you tell the jury what this is?
That is the screenshot that Fuentes sent me of her and Becker's text messages.
Was it represented to you that these text messages were accurate and unaltered?
Yes.
So is this a true and accurate representation of texts exchanged between Alex Fuentes and Avery Becker?
Yes.
Your Honor, I move that Exhibit 14 be admitted to evidence.
Objection?
Yes, Your Honor. I object to hearsay on 3 different grounds, as this exhibit contains out-of-court statements from 2 different declarants, and third of all, that overall this exhibit is being used offered for the truth of the matter asserted, as these text messages are being used to prove that Ms. Becker acted in a certain way.
Response, Your Honor.
Yes.
These texts hold 2 objections to hearsay. The first, 801D, states that they are admissible because they were statements made by an opposing party, Avery Becker. The second, 803.3, states that they're admissible because they show Avery Becker's then existing mental state of mind when Avery Becker states her plan to break into Mackenzie Brackman's house.
Response, Your Honor.
Yeah, so one question first of all. We have some statements made by the defendant and some statements not made by the defendant. So statements made by the defendant certainly will come in response to the other statements.
Your Honor, are you asking for my response?
I apologize. I'm probably saying your name wrong. Miss Mastrangelo?
Yes, Your
Certainly
Honor. It's Mastrangelo. It's Italian.
Great.
It's a little hard. I get it.
Perfect. Miss Mastrangelo, your response to the other statements.
Your Honor, I stand by my objection on the statements seemingly made by Ms. Becker in these texts, but my objection as to the out-of-court statements made by Alex Fuentes in these texts has still not been responded to.
All right, Mr. Turnage, any further response on the statements that are not a party opponent?
No, Your Honor, but the statements offered by Alex Fuentes are not offered to prove the truth of the matter asserted, and furthermore, to admit Exhibit 14 without the statements from Alex Fuentes would be an incomplete exhibit.
If they're not being used for if they're not being offered for the truth of the matter asserted, what purpose are they being offered for?
Your Honor, this exhibit is not being admitted for Alex Fuentes' text, but for Avery Becker's.
All right, this time the objection will be overruled. This exhibit will be admitted into evidence.
Thank you, Your Honor. Detective Markowitz, who sent the text shown in gray?
Avery Becker did.
How do you know this?
Because of the contact name at the top, the first text message, and in my interview with Fuentes, she told me it was a conversation with Avery.
And what did you learn from these text messages about Avery's dealings with Mr. Brackman?
I learned that Miss Becker had recently been kicked off the mock trial team and desperately wanted to get back onto the team.
Did Mr. Brackman let Avery back onto the team?
No, he did not.
But did Avery know that she wasn't going to be let back onto the team?
Yes, she was aware of that.
Knowing that she wouldn't be let back onto the team, what do Avery's second and third texts sent from the bottom show?
They show Miss Becker's plan to vandalize and trash Brackman's house while she thought Brackman would be at work.
What was the next step you took in your investigation?
Well, I reached out to Miss Becker to try and get an interview with her. However, I was unable to do so. So I got her phone number as well as cell tower records from March 6th.
What information are you able to find with cell tower records?
Well, technically what I received are call detail records, or CDRs. A CDR is a record created when you place or receive a call or text. Generally, the record shows things like the date and time of the communication, whether it was incoming or outgoing, the other phone number involved, whether it was a text or call. And most importantly, the CDR identifies the tower and specifically which antenna that the phone connects or that the phone communicates with, which is usually the nearest cell tower.
Your Honor, permission to show the witness what has previously been marked as Exhibit 16.
Yes.
Detective Markowitz, do you recognize this?
Yes.
Can you tell the jury what this is?
That is a map of the cell towers Becker's phone communicated with in the area of Becker and Brackman's phone.
And is this a true and accurate representation of a map of CDR towers near Mackenzie Brackman and Avery Becker's houses?
Yes.
Your Honor, I move that Exhibit 16 be admitted to evidence.
Objection?
Yes, Your Honor. I object on the grounds of hearsay, as the dotted blue line is an out-of-court assertion made by Detective Markowitz to show the path that the defendant would have taken using these cell tower records.
Response, Your Honor.
Yes.
Detective Markowitz will testify that the blue dotted line shown on the map is not offered to prove the truth of the matter asserted, as it is not a guaranteed route that Avery Becker took or could have taken from her house to Mackenzie Brackman's house. It is simply a path that she drew on the map based on her expertise and understanding of CDRs.
I stand by my objection, Your Honor.
At this point, the objection will be overruled. This exhibit may be admitted into evidence.
Detective Markowitz, please describe how the CDR map related to your investigation.
Well, once I examined which cell towers Becker's cell phone communicated with and transponded them on a map, which included the locations of Becker and Brackman's houses, it was pretty clear that Becker's phone was at Brackman's house at 1:17 p.m. on the afternoon of the murder.
What can you see written above each marked cell tower?
Timestamps.
And can you explain what you drew on the map?
Yeah, based on the location and order of the towers which Becker's phone communicated with, I realized there was a path that led from Avery's house pretty directly to Brackman's house.
So what does the CDR tower data indicate?
Based off the order and time at which Becker's phone communicated with the cell towers, it's pretty clear that Becker traveled from her house to Brackman's house right before the murder took place.
Detective Markowitz, based on the evidence you've just discussed, did you form any conclusions on this case?
Yes. The evidence I reviewed led me to conclude that Avery Becker entered Mackenzie Brackman's house and was surprised to find Brackman in his home. A fight then ensued, resulting in Becker gaining control of the knife and stabbing Brackman in his home.
Objection, Your Honor. Lack of foundation. No foundation has been laid as to the struggle between Mr. Brackman and Ms. Becker and the knife that came into play during the struggle.
Response, Your Honor. Detective Markowitz has been qualified as an expert in crime scene investigation, and seeing as she has been working as a detective for the Denver Police Department for over 7 years now, she's fully qualified to draw conclusions based on the evidence she observed at the crime scene.
Response, Your Honor. Your Honor, none of that evidence that counsel is referring to has been brought out in testimony today, so there's still a lack of foundation for that expert opinion.
Response, Your Honor. Detective Markowitz is not testifying to the contents of any exhibits regarding the crime scene. She is simply testifying to the opinion she formed based on the information and the evidence that she observed there.
Response, Your Honor.
Sure, last one.
Your Honor, I'm not objecting to the lack of foundation to any evidence that Detective Markowitz is testifying to. I'm objecting on lack of foundation for this expert opinion to be given, as none of that evidence or none of that testimony has come out today in trial.
At this point, I'm going to find that she is able to testify to this information. I will overrule the objection. You can continue.
Your Honor, Detective Markowitz was finished with her response, so I have no further questions. Thank you.
Cross-examination?
Yes, Your Honor. Good afternoon, Detective Markowitz. I'm going to start by asking you some questions about your investigation. Now, isn't it true that Mr. Brackman was a criminal defense attorney?
That is correct.
And isn't it true that this crime could have been the work of a disgruntled ex-client?
That's actually not true. That was one of my initial thoughts, but it is true that Avery Becker murdered Brackman.
But now you never followed up on an ex-client, now did you?
No, I did not need to.
You didn't look into any other suspects?
No, Avery Becker was my prime suspect.
Right. So now you went to the mock trial team for leads first, correct?
Yes.
And you spoke to Ms. Fuentes?
Correct.
But you didn't speak to Ms. Becker, did you?
No, I did not.
You didn't speak to Ms. Perkins?
No.
And now you didn't speak to anybody else on the mock trial team, did you?
I personally did not.
So now the evidence that led you to Avery Becker is one of 12 students on the mock trial team.
Sure, I mean, I only talked to one student, but I gathered evidence from more than just talking to Alex Cifuentes.
Now let's talk about that evidence you collected, Detective Markowitz. Now, you spoke to Ms. Cifuentes, correct?
Correct.
And you received text messages that were between Ms. Becker and Ms. Cifuentes from Ms. Cifuentes, correct?
Yes, that is correct.
But now, these were just screenshots, weren't they?
Mm-hmm.
And you received these screenshots because Ms. Cifuentes forgot to bring her phone to your interview. Isn't that right?
That is true. It was kind of weird seeing a teenager without their phone.
Right. And then she sent you these screenshots the next day. Isn't that right?
Yes, I actually asked her to do that. I think she was nervous, so she forgot her phone.
Thank you, Detective Markowitz. I heard a yes. And now Ms. Cifuentes was under the impression to send you these screenshots as soon as possible. Isn't that right?
Yes, however, she sent them to me the next morning, which is totally okay.
Right. It was sufficient for you to receive them the next day in a murder trial, correct?
Correct. It really was.
Right. And you never saw these authentic text messages, did you?
I saw the authentic screenshots.
Right. Now, Detective Markowitz, you've collected data from literally over hundreds of phones. Isn't that right?
Yes.
Using Celebrate data. Is that right?
Yep.
But now you didn't do that with Ms. Cifuentes' phone, now did you?
No, I did not.
Now let's talk about the call detail records you collected in this case. Now you collected Ms. Becker's call detail records, correct?
Correct.
And now isn't it true that Ms. Becker received many short calls from Ms. Perkins on March 6th, correct? And it's possible that these calls were never answered, isn't that right?
Based off the record, it seemed like none of them were picked up.
Right. And Ms. Becker also received many text messages from Ms. Perkins that were also unanswered, isn't that right?
Yes, which would make sense if Becker were planning on going to Rackman's house and killing him, or breaking in even. I don't think she...
Thank you, Detective Markowitz. I heard a yes. Now it's to your understanding that Ms. Becker claims to have lost her phone the day prior to these unanswered calls and texts. Isn't that right?
I heard that she claimed to have lost her phone. However, once again, it is
Thank you,
weird.
Detective Markowitz. I heard a yes. Now let's talk about the cell tower data you collected. Now you collected the cell tower data for Ms. Becker, correct?
Yes.
And now isn't it true that with the cell tower data, phones don't always connect to the nearest tower, isn't that right?
That is correct.
And now that would be because sometimes the nearest tower is unavailable, so a phone must connect to a farther away tower that is available, correct?
Yes, that's true. However, phones almost always connect to the nearest cell tower.
Right, but there's still, you can't say with 100% certainty that Miss Becker's phone connected to the nearest tower, isn't that right?
I can say with almost 99% certainty that the phone connected to the nearest cell tower.
Right, not 100. Now let's talk about that. Now let's talk about the cell tower data you didn't collect. Now, it's to your understanding that Ms. Perkins was calling and texting Ms. Becker on March 6th, correct?
Correct.
But yet, you never collected Ms. Perkins's cell tower data, did you?
No, I did not.
And if you had, you could corroborate Ms. Perkins' story about being at the mall and the fry shack on that day, couldn't you?
Yes, probably yes.
Right, and now you didn't collect cell tower data for anyone else in this case except Ms. Becker, isn't that right?
Correct.
Now let's take a look at Exhibit 16. Ms. Karras, would you please screen share Exhibit 16 as it has already been admitted into evidence? Now, Detective Markowitz, you created this diagram, correct?
Mm-hmm.
Now, would you please direct your attention to the upper left-hand quadrant? Now, there's a marked location there, Rollins' house. Is that right?
Yep.
And you marked this location yourself?
Correct.
But now you never collected the cell tower data for Blair Rollins, now did you?
No, like you said, I only collected the cell tower data for Avery Becker.
Right, and even with Ms. Rollins' house being of the same distance and vicinity as Ms. Becker's house to Mr. Brackman's house, you still didn't collect it, is that right?
That is correct.
Ms. Karras, you may stop screen sharing. Thank you. And now you only collected the cell tower data for a 35-minute period of time, isn't that right?
I found the cell tower data from March 6th.
Over a 35-minute period of time on that diagram.
On that diagram, that is what it shows.
Right. Now, according to your methods, you can pinpoint Miss Becker's location using your cell tower data. Isn't that right?
Yes.
So now, let's say if you had collected Taylor Perkins's cell tower data, you could also pinpoint Miss Perkins's location according to your methods, correct?
That is correct.
And now, in addition to this, if you collected, say, Blair Rollins' cell tower data, you could also pinpoint Blair Rollins' location according to your methods, correct?
Yes.
But you didn't, did you?
No, like I've said before, I only collected the call detail records for Avery Becker.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. Detective Markowitz, why didn't you investigate any other suspects?
Well, once I started to investigate Avery Becker, the evidence continued to mount up. I mean, Becker had motive. She was recently kicked off the mock trial team by Brackman. Becker had opportunity. According to the text with Cifuentes, Becker had a plan to trash Brackman's house when she thought that Brackman would be at work. And finally, Becker...
Objection, Your Honor, narrative. The witness is outside of the scope of the question.
Response, Your Honor. Detective Markowitz was currently testifying as to why the evidence against Avery Becker was so incriminating that she didn't need to investigate any other suspects. She was simply listing all of that evidence that led her to choose Avery Becker as her suspect.
Response, Your Honor?
Yes.
Your Honor, the question asked was, why didn't you look into any other suspects? And Detective Markowitz is now outside of the scope of that question as giving reasons for why she looked into Miss Becker, not why she didn't look into any other suspects.
Response, Your Honor.
Not necessary. I'm going to overrule that. You can continue your answer or ask the question if you'd like.
Thank you, Detective Markowitz. Why don't you finish your response from where you left off?
All right. And finally, I was going to say that there was evidence linking Becker's phone to the area of Brackman's house right before the murder took place. There was no need to investigate any other suspects because Becker had reason, means, and intention.
Thank you, Your Honor. I have no further questions.
All right, may this witness be excused? All right. Prosecution, you can call your next witness.
Yes, Your Honor. The prosecution calls Ms. Kyle Kuzak to the stand. May I proceed, Your Honor?
When you're ready.
Thank you, Your Honor. Good afternoon, Ms. Kuzak.
Good afternoon.
Please introduce yourself to the jury.
Well, hello, everyone. My name is Kyle Kuzak.
And Ms. Kuzak, what do you do?
Well, I am a crime scene reconstructionist certified by the Colorado Bureau of Investigation.
And what do you do as a crime scene reconstructionist?
Well, I normally investigate complex crime scenes such as home invasions, homicides, domestic violence, fatal accidents, armed robberies, burglaries, and other property crimes.
And Ms. Kuzak, how long have you been investigating such complex crime scenes?
Well, I've been working as a CSR for about 19 years now, and for the past 3 years of my tenure, I have been working with the City of Denver.
Thank you, Ms. Kuzak. Your Honor, I now tender Ms. Kuzak as an expert in the fields of crime scene reconstruction as well as crime scene investigation pursuant to Rule 702.
And would you mind repeating what that was in again for me?
Yes, Your Honor. That was in crime scene reconstruction and crime scene investigation.
Reconstruction and crimes investigation. Thank you. All right. Any objection or voir dire?
No objections, Your Honor.
Right. Then she shall be tendered as an expert in crime scene reconstruction and crime scene investigation.
Thank you, Your Honor. Now, Ms. Kuzak, tell me about how you professionally approach crime scenes.
Well, I have 2 key principles that I normally follow, where first I assume that every case is going to trial, so I conduct a thorough and comprehensive investigation, where second I memorialize, organize, and document all the evidence with the mindset of future reconstruction. And with these 2 key principles in mind, they allow me to have a more accurate and efficient flow with my CSR work, which I approach in the form of 5 steps.
And could you tell me about those steps?
Yes, well, step 1, this is where I create a witness tracking sheet, physical evidence tracking sheet, and a rudimentary flow chart and timeline, all of which so that I can see key physical and chronological relationships. Steps 2 and 3 is where I prepare materials for formal analysis, and then I gather all of the evidence and place it into a spreadsheet so that I can again see these physical relationships better as well. For step 4, this is where the evidence is then organized and a hypothesis is developed. And then step 5 involves my CSR initial report, which then goes into peer review, resulting in a final reconstruction report.
Thank you. Now, you mentioned a witness tracking sheet. Could you tell us more about that?
Yes, well, this witness tracking sheet of mine is specifically in step 1 out of my step 5 process. And this is where I go into a little bit more depth as to who had been interviewed by the police, and also helps me to determine who had possible connections with Mr. Brackman prior to his death.
Ms. Kuzak, would you recognize a copy of the witness tracking sheet you prepared for this case if it were shown to you?
I would, yes.
Your Honor, I request permission to show Ms. Kuzak what has been previously marked as Exhibit 17. And I would like to make it clear before we begin that I would just like to admit the witness tracking sheet portion of this exhibit. I have no intent to talk about either the rudimentary flowchart or the evidence tracking sheet.
Noted.
Thank you, Your Honor. Now, Ms. Kuzak, do you recognize this?
I do, yes.
Could you please tell the jury what this is?
Well, this is my witness information tracking sheet, which I produce as a part of my reconstruction process.
And Ms. Kuzak, is this a fair and accurate representation of the witness tracking sheet you prepared for this case?
It is, yes.
Your Honor, I ask that Exhibit 17 be admitted into evidence.
Any objection?
Yes, Your Honor, I object on the grounds of hearsay.
Response, Your Honor?
Yes.
Pursuant to Rule 8036, this is an exception to hearsay as it is a regularly conducted activity.
Response, Your Honor?
Yes, response to 8036.
Your Honor, this is not a regularly conducted business activity as it was created in anticipation of litigation and solely for this case. In addition, it contains Ms. Kuzak's evidence that is substantial to this case and is not permissible under hearsay.
Response, Your Honor? I'm sorry, I think your audio cut out. Thank you,
Sorry,
Your Honor.
yes, you may respond.
Thank you, Your Honor. In response to that, as Ms. Kuzak has made it clear, she creates a witness tracking sheet every single time she has a case. And this is the one that she created for this case. Therefore, it is part of that regularly conducted activity. This practice of making the witness tracking sheet is that regularly conducted activity and is thus exempt from hearsay.
Response, Your Honor?
No further response needed at this time. I am going to overrule the objection and allow this to be admitted into evidence.
Thank you, Your Honor. Now, Ms. Kuzak, what is the significance of this particular witness tracking sheet?
Well, the police department for the city of Denver was able to conduct a thorough investigation for this specific crime, interviewing multiple people who might have had possible connections with Mr. Brackman, including witnesses in court today, as well as other former Colorado high school students.
And what were some of those other former Colorado high school students?
Well, as you can see from my witness tracking sheet, you can note that Brandon Digby was another former Colorado high school student. And you can also note that Blair Rollins was another one, but was an unlocated party and could not be contacted for interview.
Thank you, Ms. Kuzak. Timekeeper, if you could take that down, please. Now, Ms. Kuzak, how do all of these moving parts play a role in how you come to a conclusion when it comes to cases?
Well, this way of approaching crime scenes gives me a more clear and detailed view of what exactly happened at the given crime scene.
Thank you, Ms. Kuzak. I'd like to move on to the scene of the crime, at 444 South Flower Street on March 6, 2020. Tell me a little bit about the physical setup of this particular crime scene.
Well, while I was investigating the residence, the first thing that I noticed were scuff marks that were immediately inside of the back door. Then as I moved from that back entrance to the kitchen area, there was a broken plate on the floor and an open knife drawer and a knife block with one empty slot. Then as I moved from that kitchen area to the front entrance, there was a blood trail which ended where Mr. Brackman had been found by the police. Additionally, I was also able to review the security footage showing a masked individual roaming around the residence prior to Mr. Brackman's death.
And could you tell me more about that security footage?
Well, the security footage was taken from the Ring security camera system that was set up just outside of the residence, all of which pointing towards different entry points, such as the front door, the south side gate, as well as the back door.
And would you recognize copies of these Ring security videos if they were shown to you?
I would, yes.
Your Honor, I request permission to pull what has been previously marked as Exhibits 12 and 13.
Certainly.
Ms. Kuzak, do you recognize this?
I do, yes.
Could you please tell us what this is?
Well, this is the third out of 4 videos that I was able to review. And in this particular video, it is showing the masked individual entering the residence through the back glass sliding door. Now, for this to have had occurred, this individual...
Your Honor, narrative, the witness is now beyond the scope of the question and is testifying to what she believes the perpetrator was doing.
Response?
Yes, as Ms. Kuzak has said, in order for the perpetrator to have come to the back sliding glass door, she's simply noting that they would have had to have gone through the south side gate. There's no other, pardon me, I just wanted to note that in order for this to have happened, Ms. Kuzak is simply noting that the perpetrator would have had to come around the residence.
At this time, I'm going to overrule, but if it does go too much further, please re-raise your objection.
Yes, Your Honor.
Ms. Kuzak, if you could please finish what you were saying.
Yes, well, from this particular video, you can see the masked individual enter through the residence through the back door. And for this to have had happened, this masked individual would have had to move around the residence and enter through the south side gate in order to get to this back door.
Thank you, Ms. Kuzak. And is this a fair and accurate representation of this third ring video?
It is, yes.
Your Honor, I ask that Exhibit 12 be admitted into evidence.
Any objection?
No objection, Your Honor.
It shall be admitted.
Thank you, Your Honor. Now, timekeeper, if you could please move to Exhibit 13. Ms. Kuzak, do you recognize this?
I do, yes.
And could you please tell us what this is?
Well, this is the 4th and final video that I was able to review. And in this particular video, it is showing the same masked individual now running out of the residence through the front door, escaping the scene.
And is this a fair and accurate representation of this 4th and final ring video?
It is, yes.
Your Honor, I ask that Exhibit 13 be admitted into evidence.
Any objection?
No objection, Your Honor.
Shall be admitted.
Thank you, Your Honor. Now, Ms. Kuzak, how did these ring security videos play a role in how you came to a conclusion about this case?
Well, the individual matching the general height and build of the defendant sitting here today, Avery Becker, was roaming around the residence, getting caught in all the security cameras, was sending notifications to Mr. Brackman's phone, alerting him that there's motion happening outside of the house. Now, this would have given Mr. Brackman time to arm himself and prepare before this individual would have then entered through that back door.
Now, Ms. Kuzak, what would have happened if Mr. Brackman didn't have his notifications on, or if his phone was away from him?
If Mr. Brackman didn't have his phone on him or was in the instance where his notifications were turned off, he would have either at least heard the back glass sliding door open or would have heard the individual shuffling around the kitchen area once inside.
Now, what would have happened after the perpetrator entered the residence?
Well, I believe there to be a scuffle that immediately ensued.
Could you tell me about that?
Well, this struggle occurred immediately inside and to the right of the back entrance based on the scuff marks on the floor, which indicate that more than one person were in close contact there. That struggle would have then continued to move from that back area to the kitchen area where the plate was knocked off the table and where Mr. Brackman was disarmed of his weapon and stabbed in the back of his upper left shoulder in a bear hug formation. That struggle would have then continued to move from that kitchen area to the front entrance where the knife would have then been removed out of Mr. Brackman's back, resulting in immediate death by the front door.
Thank you, Ms. Kuzak. Now, I have one final question. In all of your 19 years of experience in investigating such complex crime scenes, what are your final thoughts on this case?
Well, my final thoughts are is that this was a planned burglary gone bad. You know, the intruder clearly had knowledge of the residence and chose a day and time in which Mr. Brackman would have most likely been outside of the house. However, on this particular day, Mr. Brackman was in fact home, resulting in the victim coming in close contact with the intruder, the disarming of the victim, and then resulting in the unfortunate death of Mr. Brackman.
Thank you, Ms. Kuzak. Thank you, Your Honor. I have no further questions.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Kuzak. I'm going to begin by asking you a few questions about your initial investigation. Isn't it true that you arrived at the crime scene after it had been processed?
That is right, yes.
And this meant that you had to rely on previously gathered evidence such as police reports and photographs, correct?
Yes, but I was also able to do a walkthrough of the residence and get a sense of the residence as well.
Ms. Mastrangelo, can you please share exhibits 1 and 4? Ms. Kuzak, can you please identify what has been previously marked as exhibit 1?
Well, this is a photo showing Mr. Brackman, who had ended up by the front entrance.
And Ms. Kuzak, can you please identify what has been previously marked as exhibit 4?
Well, this is another photo from a different angle showing Mr. Brackman after the murder had occurred.
And are these both fair and accurate representations of the crime scene as you observed it?
They are, yes.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified exhibits 1 and 4. Your Honor, I now move to enter exhibit 1 into evidence.
Any objection?
No, Your Honor.
All right, they shall be admitted.
And Your Honor, I now move to enter exhibit 4 into evidence.
No, Your Honor. I believe you asked if there are any objections. You were on mute, but no, Your Honor.
I was on mute, I'm sorry. So no specific objection to exhibit 4 either. It shall also be admitted.
Yes, Your Honor. Now, Ms. Kuzak, please look at exhibits 1 and 4. The victim's right hand is not in the same position in both of these, is it?
No, I suppose not.
And now please look at exhibit 4. Isn't it true that the victim has what appears to be a wedding band on his left ring finger?
Yes, that's right.
Yet these matters are not mentioned anywhere in your report, are they?
No, they are not.
And you stated in your direct that Blair Rollins was someone you considered, yet they were unable to be reached for your investigation. Isn't that correct?
Yes, they were an unlocated party. That's correct.
So you did no further investigation into this suspect, correct?
Well, I am a crime scene reconstructionist. I reconstruct the scene. I don't necessarily identify suspects.
But according to your witness tracking sheet, you did not do any further investigation, according to Blair Rollins, correct?
Well, according to my witness tracking sheet, it's information that I gathered from the police interviews that I collected.
Next, I'm going to ask you about your theories in regard to the knife. You're aware that the defendant is a high school girl, right?
Yes, I am aware.
And you're also aware that Mr. Brackman is a grown man, correct?
Yes, I am.
Yet you claim that a small high school girl managed to disarm a full-grown man?
Yes.
You also determined, based off of the autopsy report, that the knife was lodged in the victim's scapula, correct?
Yes, and it nicked the aorta. That's correct.
And this would have made it very hard to pull out the knife, correct?
Yes, I suppose so.
And even considering this, isn't it true that you claimed that the already weak victim must have pulled out the blade himself?
Yes, I noted that Mr. Brackman pulled out the knife himself.
Next, I'm going to ask you about the missing files. Isn't it true that part of your reconstruction relied on photographs of the blood spatter?
Yes, they were unfortunately corrupted, but they did not waver my conclusion on this case, seeing as though I was able to review them before their corruption.
So these photos no longer exist, correct?
No, they do not. I don't believe so.
So neither the jury nor the defense has access to those, right?
No, they don't.
Finally, I'm going to ask you about the conclusions that you made. You assumed that there was no way for the victim to have been surprised by the intruder, correct?
Yes, that is correct. There's a lot of...
Thank you. I heard a yes. Isn't it true that you assumed that Mr. Brackman received alerts from the Ring app?
He either would have heard the notifications from the Ring app or would have heard the door opening or would have heard the intruder once inside of the residence.
Ms. Kuzak, you didn't answer my question. You assumed that Mr. Brackman received these alerts, correct?
Yes.
But you have no physical evidence of this, correct?
No, I do not.
And then you go on to further assume that if Mr. Brackman received the alerts, he chose to engage the potential intruder, right?
Yes, that's right.
You're assuming that Mr. Brackman chose to engage instead of calling 911?
Well, I think that in the circumstance where there's an intruder who's trying to get into your house, you only have a matter of seconds to react, you know?
Ms. Kuzak, you're not answering my question. You're assuming that Mr. Brackman chose to engage instead of calling 911?
I don't believe that Mr. Brackman had time to call 911, seeing as though the intruder was coming around the residence in a matter of seconds.
You're assuming that Mr. Brackman chose to engage instead of simply locking the back door?
Well, yes.
And you're assuming that Mr. Brackman chose to engage instead of running out the front door?
Yes, that's correct.
And isn't it correct that you cannot know for certain whether the victim heard the back door open?
I cannot.
And finally, you claim that you would prefer having more physical evidence. Isn't that true?
Well, that's the same thing with every case, where I always would prefer to have more physical evidence. But in this particular case, seeing as though the victim and the intruder were only in close contact for a short while, there wasn't a lot of physical evidence that would have been created in that short time of close contact.
So that's a yes, Ms. Kuzak?
Yes, I do wish that. I always do.
And this means that you did not have all evidence in order to recreate all segments of the event, correct?
I had enough evidence to come to my conclusions on this case.
So that is a yes, you did not have all evidence in order to recreate all segments of the event, correct?
I believe I had access to all of the evidence that was at this particular crime scene.
Thank you. No further questions, Your Honor.
All right, redirect?
No, Your Honor. The prosecution has no redirect for Ms. Kuzak.
All right, then this witness may be excused. The prosecution, when you're ready, you can call your next witness. All right, and begin when you're ready.
I'm sorry, Your Honor, my internet cut out. May I proceed?
Yes, you may.
Okay, thank you. Hello, Mrs. Fuentes.
Hello.
Would you please introduce yourself to the jury?
Yes, hello. My name is Alex Fuentes, and I was a junior at Colorado High School, but most people call it CHS. And while attending CHS, I am a member of the mock trial team.
Thank you. And would you further describe your experience participating in mock trial?
Yeah, so I began mock trial my freshman year when Avery convinced me to try out. I really liked it, and I worked extremely hard during practices and tournaments.
And could you explain more about your relationship with your mock trial teammates?
Yeah, so I'd say my best friend on mock trial was Avery. We did it together through most of high school and spent most of our time hanging out through practices and tournaments. I had a really good time with Avery. However, I didn't really appreciate her antics on the team. We had some issues with Avery as time went on.
Thank you. Your Honor, I would ask that Avery Becker turn her camera on for purposes of identification.
Sorry, could you say that one more time?
I ask that Avery Becker turn her camera on for purposes of identification.
Certainly.
Mr. Fuentes, do you see Avery Becker on screen today?
I do.
Could you describe how Avery Becker appears on screen?
Yes, she's wearing a gray blazer and a white blouse.
Thank you. Your Honor, let the record reflect that Alex Fuentes has identified Avery Becker as the defendant in court today.
The record shall so reflect.
Your Honor, I no longer need Avery Becker's presence on screen. Now, Ms. Fuentes, you described some issues within the team. Would you elaborate on those, please?
Yeah, so for starters, we had some trouble getting Avery to take mock trial seriously. Mock trial came very naturally to Avery, so she got away with not putting in as much effort and frequently came to practices either late or unprepared, sometimes both.
And how did you observe this behavior affect the team's coach, Mr. Brackman?
I saw that this really bothered Coach Brackman. Coach Brackman was a really good lawyer and cared for our team. He had another job and still found time to deal with all of us. So I understand why he seemed frustrated with the fact that Avery slacked off. It seemed like Avery and Brackman pretty much hated each other and were always feuding.
And could you tell me about some of Avery's roles on mock trial?
Yeah, so Avery played a witness role as well as an attorney and was equally as skilled at both.
Objection, Your Honor, relevance.
Response?
Your Honor, pursuant to Rule 608, this goes to the defendant's truthfulness and is therefore admissible.
Response, Your Honor.
Yes.
Your Honor, then this would be under improper character evidence, and the foundation has not been laid as well to determine Ms. Becker's participation and truthfulness.
All right, response to character evidence and foundation.
Your Honor, this evidence is not being offered to suggest that Ms. Becker acted in accordance with a certain character trait, and it is rather going to her credibility, which is admissible under 608 as well.
Okay, for the response?
Your Honor, the proper foundation has still not been laid as to how the truthfulness of Ms. Becker could be determined.
Response, Your Honor.
Yes.
If my witness were allowed to continue with her answer, then the foundation would be clear.
All right, so this time I'm going to overrule and give you that leeway to finish laying that foundation or clear it up. If that's still unclear after this, please re-raise your objection.
Thank you, Your Honor. Ms. Fuentes, would you continue with your answer?
Yeah, so like I was saying, Avery was really skilled at mock trial and had this amazing ability to make things up on the fly, especially on a witness stand. She could make the listeners believe any part of her testimony was true.
Now, Ms. Fuentes, did you ever witness any specific interactions between Mr. Brackman and Ms. Becker?
Yes, I remember one specific time Avery was late to practice for the upteenth time. Coach Brackman then kicked Avery off of A team, bumping her down to B team. I then later found out that Avery had convinced Taylor Perkins.
Objection, Your Honor, narrative. The question is, or the answer is outside the scope of the question.
Response?
Your Honor, I'll move on.
Certainly, then that shall be sustained. You can continue.
Ms. Fuentes, what happened after this?
Well, after that, Avery was kicked off of the A team, but then found her way back onto the A team just in time for regionals.
Mm-hmm. And what happened at regionals?
Avery won Best Attorney Award and Best Closing Argument Award that year.
And after he won the 2 awards, what happened?
Well, at the next practice, Coach Brackman came up to talk to Avery, and they got in a disagreement about Avery's work ethic and how it needed to change.
And was that the end of their dispute?
No, so after Avery and Brackman had that argument, Avery went out to Coach Brackman's car and vandalized it, writing the Worst Attorney Award right on the hood of his Porsche. After that, Avery was removed permanently from the team.
I'm sorry, Your Honor. I believe my internet froze again. Ms. Fuentes, would you?
Looks like she froze again. We'll give that just 1 second.
Your Honor, do you request time to be stopped at this by saying 1 minute?
That would be great. Yeah, if you want to stop it while we get this sorted out.
I'm sorry. I think I'm back. Can you all hear?
I think you're back now. All right, you can continue.
Sorry. Permission to re-ask my last question?
Yes.
Was that the end of their dispute, Ms. Fuentes?
No, so after that, Avery and Coach Brackman got in this fight, and Avery vandalized Coach Brackman's car, and then Avery was removed permanently from the team.
Shoot, I'm so sorry. My internet froze again. Ms. Fuentes, could you repeat your answer, please?
Yes, so Avery vandalized Coach Brackman's car and was removed permanently from the team.
And after that, what happened, Ms. Fuentes?
After that, Avery texted me asking me to convince Coach Brackman to let her back on the team, so I agreed to see if that would be possible. And Avery said, well, if he—
Stop.
Thank you, Your Honor.
All right. Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Fuentes. I'm going to start off talking a little bit about mock trial. The mock trial meant a lot to you, correct?
Yes, it did. I started it freshman year, and I really loved it.
And you worked really hard in your assignments, didn't you?
Yes, I did.
Isn't it true that it irked you the way Ms. Becker participated in mock trial?
Yeah, I mean, as someone who put in so much effort, I really didn't appreciate someone succeeding a little more than me when I just tried so hard. It was one of my passions.
And you had a friendly competition with Ms. Becker, is that right?
I'm sorry, could you repeat that question? I cannot hear you.
You had a friendly competition with Ms. Becker, correct?
Yeah, we pushed each other to be better. I saw the potential in her.
But isn't it true that you believe Ms. Becker won her awards, not because of talent, but because of good looks?
I did say that, yes.
And you were envious when Ms. Becker won her awards, correct?
I mean, wouldn't you be? I put in so much effort.
You saw it as a slap in the face, correct?
I did say that, yes. And if, like,
Thank you, Ms. Fuentes. I heard a yes. And let's move on more to your relationship with Ms. Becker. You claim you're pretty good friends with Ms. Becker, is that right?
Yes.
But isn't it true that you think criminal charges should have been pressed against your good friend after the car incident?
Yes, I believe so. It was vandalization of our coach's car.
And isn't it true that you were excited for Ms. Becker to be removed from the team because it meant that you would receive a larger role?
I'm sorry, could you repeat that question? I believe you froze.
Isn't it true that you were excited for Ms. Becker to be removed from the team because it meant that you would receive a larger role?
Yes. I mean, I guess so. Like, we had a friendly competition with mock trial, like I said in my previous answer. So
Thank you, Ms. Fuentes. I heard a yes.
A larger
And isn't
role.
it true that you really didn't see your good friend Ms. Becker that often outside of mock trial?
I saw her at the Fry Shack a few times.
But not that often, correct?
I'm sorry, that's really not in my witness statement if you would like me to respond.
I'll move on. Now, I'm going to talk more about March 5th. You were at the Fry Shack on March 5th, correct?
Yes, I was.
And you saw Ms. Becker and Ms. Perkins there, is that right?
Yes, along with
And you
mock trial students.
and you even played a game on Ms. Becker's phone, is that right?
Yes, I did. She let me play a game while she went to the bathroom.
So it's true then that you had Ms. Becker's phone in your possession the day she lost it?
I played a game on her phone. So
Thank you, Ms. Fuentes. I heard a yes. Now let's move on and talk about the interview that you had. You got a call to go down to the police station for an interview, correct?
I did, yes.
And you were aware you were going down for a full interview?
Yes.
So you knew that you needed to bring your phone to show the text you claimed to have received from Ms. Becker, is that right?
Yes, which is why I made sure to charge it right before I left for the interview. And I was really dumb and totally left my phone on the charger when it was time to go.
Right. So you didn't bring your phone to the interview, did you?
I totally left it on the charger. I left it at my house. So I offered to come back with it, but they said that they were fine with the screenshots.
So it's true then that Detective Markowitz didn't see these text messages directly off of your phone?
Not directly off of my phone, no, but they saw the screenshots, which are the exact text messages that happened between me and Avery.
Right. The screenshots that you sent the day after the interview, correct?
Yes, I did send them the day after.
So when you received these text messages, you didn't call the police, did you, Ms. Fuentes?
No.
You didn't notify the school?
No.
You didn't tell Mr. Brackman, did you, Mr. Fuentes?
No, I didn't really know the seriousness in these text messages and the extent.
Thank you, Mr. Fuentes.
Through.
So right when you received these text messages containing a threat about the coach that you cared about, you didn't tell anyone, did you?
No, like I said in my previous answer, I didn't really know the extent to these text messages.
Thank you. No further questions at this time, Your Honor.
Any redirect?
No, Your Honor. The prosecution rests.
Perfect. All right. Any further witnesses from the prosecution? So you just said you rested. I don't know why I asked that. Defense? You may call your first witness.
Yes, Your Honor. The defense calls its first witness, Miss Taylor Perkins, to the stand.
All right. You may begin when you're ready.
Good afternoon, Ms. Perkins. Can you please introduce yourself to the jury?
Good afternoon. My name is Taylor Perkins, and I'm a freshman at CU Boulder.
Ms. Perkins, why are you here today?
I'm here today because Avery didn't do this. She was with me the entire day.
Can you be a little bit more specific about the time that you were together?
Sure, we were together the morning, the afternoon, and up till about dinner time.
And what is the significance of this time period?
Well, to my understanding, this is the time period that Coach, he unfortunately died.
I know this is hard for you. Let's talk about mock trial. Were you on the mock trial team?
I was, yes.
Who was on the team with you?
Well, there's a lot of people in our mock trial team, but out of the people here today, Alex Fuentes and my bestie my bestie Avery Becker was on the team.
Who was your coach?
Coach Brackman was our coach.
I know this is very difficult. Let's talk a little bit more about mock trial. Did you enjoy mock trial?
I did, yes. It was super fun.
Would you say that you were good at mock trial?
I would say I was pretty good, yeah.
Was Miss Becker good at it?
Avery was amazing. I mean, it was incredible to watch her, just inspiring.
Now, let's talk about some of the other relationships in mock trial. What was your relationship with Mr. Brackman?
We had a good student-teacher relationship.
From your observations and practices together, what was the relationship like between Mr. Brackman and Miss Becker?
I would say they had a complicated, they had a complicated relationship. Coach Brackman, he really liked, organization and structure. And well, Avery, she kind of went off script sometimes, which he didn't really love.
Can you tell the jury about some differences that you observed between the two of them?
Well, I know they argued a lot during practice.
And you also mentioned that you were on mock trial with Miss Cifuentes. What was that relationship like?
Well, Alex and I weren't particularly close. We worked well together on the team.
Now let's talk about some of the other relationships at Colorado High School. Do you know of any other students that had a relationship with Mr. Brackman?
Yes, Blair Rollins.
Was Miss Rollins on the mock trial team?
She wasn't, no, but she was actually really good friends with Alex.
Do you know Miss Rollins?
Not personally, but, most of CHS does. I mean, her dad, he was actually sent to jail on
personal knowledge. Rule 602, I believe.
Your Honor, I believe you're muted. I cannot hear you.
Can you hear me?
Yes, now I can.
Fantastic. Response?
Yes, Your Honor. The witness has personal knowledge as she was in school with Blair and has knowledge of this case that gained large attention from both her coach and Miss Rollins, who was at school with her.
Response?
Ms. Perkins has just testified that she was not close at all with Blair Rollins, and so she would not have proper personal knowledge, considering she wasn't present in the trial in which she was convicted, nor was she close at all with Blair Rollins. So I would argue that she doesn't have proper personal knowledge.
This time I'm going to sustain. If you can lay more foundation, you can re-ask that question.
Ms. Perkins, do you know of anyone close with Miss Rollins?
Yes, Alex Fuentes.
And did Miss Cifuentes ever speak about Miss Rollins?
Well, not exactly.
Question calls for hearsay.
Your Honor, I'll rephrase.
So.
Your Honor, sorry, Miss Perkins, is Miss Rollins in the courtroom here today?
No, she's not actually. She kind of just disappeared after graduation and no one really knows where she is.
Now let's talk about some conflicts between Mr. Brackman and Miss Becker that you observed. What happened when Miss Becker went off script?
Well, I remember this one specific practice where Avery came in and, well, she went off script. And they do sometimes, they argued and coach actually moved her down to the B team. And Avery was actually later kicked off of the team.
What did you decide to do after Miss Becker was demoted to the B team?
Well, I thought it over for a few weeks and I eventually decided to step down from the team.
Why did you make that decision?
Well, it was mostly for the good of the whole team. I really wanted us to make it to state, and Avery was definitely A team material. So if I left, coach would give my spot to Avery. So the team would make it to state.
Now let's talk about the night of March 5th. What did you do that evening?
Well, Avery had come over to my house and we hung out a little bit, and then we headed out to the Fry Shack.
And what happened while you were at the Fry Shack?
While we were there, some mock trial students actually showed up.
Once they arrived, what happened?
Well, at one point, Alex came over and sat down and talked with us for a little bit.
Once Alex sat down, what happened next?
Avery actually, she put down her phone on the table and she went up it to go to the bathroom.
What happened next?
Well, Avery came back from the bathroom and we headed out to the mall.
Where did you see Miss Becker's phone last?
The last place I remember it was right on the table next to Alex.
And now let's move on to the day of March 6th. What happened that morning?
That morning, I had texted Avery to see if she was going to come pick me up from school like I normally do, but she never replied.
And what happened after that?
Well, she actually did end up coming to pick me up for school. And I asked her why she didn't answer my texts. And that's the point we realized that her phone was actually missing.
What did you decide to do after that?
We decided to skip school and go look for her phone.
Where did you go first?
Well, we really wanted to retrace our steps from the night before. So the first place we headed was the mall.
And what did you do while you were at the mall?
Well, we burned through pretty much the whole day there looking because we had gone to a bunch of stores the night before. So, I mean, it took us a long time to retrace all our steps because we had to go through each store like in detail, and it took a lot of time.
After you and Miss Becker spent the day at the mall, where did you go next?
Well, I was getting hungry and I was, around dinner time. So we headed to the Fry Shack. And that's the point where I actually remembered seeing Avery's phone on the table. So
now let's move on and talk about what happened after your coach passed away. You testified that you were with Miss Becker the entire day. Did the police ever contact you?
No, I'm sorry, the police, they never came to me to talk to me about how I was with Avery the entire day. And I never understood why they didn't do that.
Did anyone ever contact you?
Avery's lawyers, they contacted me actually, but I was shocked when I heard from them actually.
Why were you shocked?
Well, Avery shouldn't have even needed lawyers. I mean, there's no possible way that she could have done this.
How do you know?
She was with me the entire day. We went to the mall and we went to the Fry Shack, nowhere even close to Brockman's house. I mean, there's no possible way she could have been two places at once. Avery didn't do this.
Thank you, Ms. Perkins. Your Honor, I have no further questions at this time.
Cross-examination?
Yes, Your Honor, may I proceed?
You're ready, yes.
Good afternoon, Ms. Perkins.
Good
You went to
afternoon.
Colorado High School.
Yes, I did.
And at Colorado High School, you participated in the mock trial program.
Yes, I thought it was super fun and it was a good way to hang out with Avery.
And you were coached by Mackenzie Brackman.
Yes, coach was our coach.
But you and Miss Becker didn't always agree with Mr. Brackman.
Well, no one can agree with someone 100% of the time, so no, we didn't.
You and Miss Becker thought that he was a mediocre coach.
I know I said that at the time, but like everyone, makes mistakes.
Ms.
So
Perkins, for the sake of expediency, I would ask you to answer with a simple yes or no. If this were a normal trial, I would let you elaborate. But my co-counsel and I only have 20 minutes. Thank you.
Okay.
And you also thought that he was a mediocre lawyer, correct?
well, I don't know how he performed as a lawyer, but I did say that.
And you call Mr. Brackman and Miss Becker's disagreements their little feud.
I do believe they had a little feud, yes.
And Miss Becker drove Brackman crazy.
Objection, Your Honor, speculation.
Response?
Your Honor, I'll allow the witness to testify on her rationally based perception of what she observed, but seeing that she observed specific arguments and conflicts between Brackman and Becker and that she's previously stated this, I would consider it not speculation.
Your response to that?
Your Honor, the witness cannot testify to what Miss Becker did, saw, or thought, as she is not Miss Becker.
At this time, I'm going to overrule the objection and allow the witness to testify to what is within her personal knowledge.
Thank you. Permission to ask the question again?
You may. No, you're fine. You may re-ask.
Miss Becker drove Brackman crazy, correct?
Well, I'm not Mr. Brackman, so I don't know how he felt, but from my observations, that's how he seemed.
Mm-hmm. But you didn't really get involved in their arguments, correct?
No, I didn't really feel the need to. I mean, Avery could handle it herself.
But these arguments did bother Miss Becker, correct?
Well, yeah, I mean, mock trial meant a lot to her, so it was hard on her that he didn't really,
Thank you. You answered my question. And Miss Becker could be rash, correct?
She could be a little bit irrational at times, but not enough to hurt anyone.
And she had an inflated ego as well, correct?
A little bit, yeah.
All right, so Miss Becker decided to enact pranks on Mr. Brackman, correct?
Nothing that would harm anyone, but yes.
And after one argument with Miss Becker, Mr. Brackman got heated, correct?
I'm sorry, which argument?
The argument in which he berated Miss Becker for winning the 2 awards.
Could you repeat the question?
Yes. And after one argument with Miss Becker, you say that Mr. Brackman got heated.
Well, at that point, I was off the mock trial team, so I don't specifically know what happened, but from what I heard, that's what happened.
And he then demoted Miss Becker to the B team.
Yes, he did.
And after this, you stepped down from the A team.
I did. It was, I think, the best choice I could make at the time.
And the intent of you stepping down from A team was so that your best friend, Miss Becker, could be back on the A team, correct?
That was part of it, but another part was so our team could make it to state.
Mm-hmm. All right, I'd like to move on and discuss the night on which Miss Becker vandalized Mr. Brackman's car. So they got into another argument, correct?
I wasn't there, but that's what I heard.
Mm-hmm. And after this argument, Miss Becker vandalized Mr. Brackman's car, right?
Objection.
I assume that's what.
Your Honor, the witness has already testified that she wasn't there, and therefore this is speculation.
Response, Your Honor?
Yes.
Considering that the witness has testified that she is best friends with Avery Becker and that she was aware of this enough to put it in her witness statement, she would have proper knowledge for this to not be considered speculation.
Your response?
I stand by my objection.
All right, what I'm going to do this time is overrule. If the witness does not know, she is free to testify to that. Otherwise, you may continue questioning.
Thank you. In your witness statement, Ms. Perkins, you state that this was Ms. Becker's way of letting off some steam, correct?
Objection, Your Honor. Improper impeachment. According to Rule 613, you cannot directly quote from a witness statement when talking to the witness.
I am going to sustain that objection. Please rephrase your question.
All right. Ms. Becker did this to let off some steam, correct?
That's what I heard from her, yes.
Mm-hmm. And Ms. Becker did this to freak Coach Brackman out, correct?
I think so. That's what Avery told me.
Mm-hmm. And then after this incident, Ms. Becker was kicked off the mock trial team permanently, correct?
She was, unfortunately.
Thank you. Once again, I'd like to move on and now discuss the night you and Ms. Becker went to the Fry Shack. So on this night, you were at your house.
Yes.
And you and Miss Becker, were playing games on your phones.
This is March 5th, correct?
Yes, I'm sorry.
Okay. Yes, we were.
You went to eat at the Fry Shack.
Yes, we did.
And at the Fry Shack, Miss Becker got upset, correct?
Alex had said some, from my point of view, insincere comments to her about mock trial. So yes, she did get upset.
And she stormed off to the bathroom.
Yes, I think that's what happened.
But she left her phone at the table.
Right next to Alex.
Mm-hmm. And this was weird because Miss Becker's phone was like her third kidney, correct?
Pretty much, but she pretty much always put it down when she went to the bathroom.
Thank you. Now, while Ms. Becker was in the bathroom, you spoke with Alex Cifuentes, correct?
This is true.
And you expressed your urge to punch Alex in the face, correct?
Objection, Your Honor. This question goes to hearsay.
Response?
Your Honor, she mentions this urge in her witness statement, and therefore it's an in-court statement.
Your Honor, counsel cannot address things as in her witness statement as it is improper impeachment, and I stand by my objection.
So to clarify, you're saying this is hearsay. Who are you saying the statement came from? Are you just saying that it's from a document?
Ms. Perkins wrote in her witness statement that she felt the urge to punch Alex Cifuentes in the face. I'm not sure if she actually stated anything.
I did.
All right, this time I'm going to overrule the objection. You may continue.
Thank you. I'd now like to discuss with you the events that followed Mr. Brackman's death. So when you heard Mr. Brackman had been killed, you and Avery talked about it, correct?
We did. I mean, Coach Brackman was a big part of both of our lives. He was our coach for many, many years, and he was really important to us.
I understand. And after Miss Becker's lawyers called you, you spoke with Avery again, correct?
I did. I mean, Avery and I are best friends, so we talk a lot.
So then, Miss Perkins, it's true that you spoke with Avery at least twice before you spoke with the police?
Yes, I just don't see what that has to do with anything.
And Miss Becker told you at one point that Blair Rowlands was involved in the case, correct?
Well, she said Blair could have been involved, yeah.
But it wasn't a lawyer who told you that Blair Rowlands was involved in the case, correct?
No.
And it wasn't a police investigator who told you that Blair Rowlands was involved in the case, correct?
No.
So to clarify, it was Avery Becker, who is on trial for murder, that told you that Blair Rowlands was possibly involved in the case, correct?
I don't see the significance of that, but yes.
Mm-hmm. And finally, you suggest that Alex Cifuentes could have given Blair Rowlands Ms. Becker's phone, correct?
Well, Alex was the last person I saw the phone with, so that's that's a possibility, yes.
However, you didn't witness this happen, correct?
No, like I said, it's a possibility.
Nor did you witness Ms. Cifuentes or Mr. Rowlands with Ms. Becker's phone, correct?
No, like I said, it's a possibility.
All right, thank you, Your Honor. I have no further questions.
Redirect examination?
No redirect necessary, Your Honor.
Certainly. All right, this witness may be excused. Defense, you can call your next witness.
Your Honor, the defense calls its next witness to the stand, Professor Blake Van Owen.
Begin when you're ready.
Yes, Your Honor. Good evening, Professor. Would you introduce yourself to the jury, please?
Good evening. My name is Professor Van Owen.
And why are you here today?
I'm here today to show that the prosecution's case is faulty and unsound.
Professor, let's start with your qualifications. What is your current occupation?
As of now, I work 2 different occupations, the first of those being a professor of police practices and social justice up at CU Denver, and I work as a private investigator on the side.
What does being a private investigator entail?
Most of my work is the analysis, evaluation, and interpretation of different investigations, such as the one conducted by Markowitz today. And then I also avail myself as an expert witness across district and state courts.
Do you have any areas of expertise you specialize in?
I specialize in cell tower analysis, crime scene reconstruction, and general police investigation tactics.
What is your education in those fields?
I have a master's degree from Ashford University, and I consider the 8+ years of on-the-job experience quite educational.
Do you have any other experience in these fields?
As part of my job is the availment as an expert witness. I have been accepted as an expert in the areas of crime scene reconstruction 8 times, cell tower analysis 5 times, and general police investigation tactics 12 times.
Your Honor, pursuant to Rule 702, testimony by experts, and Rule 703, basis of an expert's opinion, I'm tendering Professor Blake Van Owen as a qualified expert in the fields of crime scene reconstruction, cell tower analysis, and general police investigation tactics.
One more time for me, that was crime scene reconstruction, cell tower analysis.
And general police investigation tactics, Your Honor.
Any objection or voir dire?
Yes, Your Honor, the prosecution requests a brief voir dire.
Certainly.
Now, Mr. Van Owen, you don't mention any classes you have taken in regards to cell tower analysis.
Other than the many classes I took in pursuit of my master's degree, no.
Oh, and your master's degree was in criminal justice. Am I correct in saying that?
That's correct, yes.
So you wouldn't have taken classes on cell tower analysis with a master's if you were going through a master's in criminal justice, correct?
This is beyond the scope of my witness statement, but I'd be happy to answer in character if you'd like.
No, that's fine. Thank you. But I would just like to make it clear that you do not specifically mention any classes you have taken in regards to specifically cell tower analysis.
Criminal justice is a broad field which covers all topics, including police investigation tactics, as cell tower analysis
Thank you,
is
Mr.
a
Van
sub.
Owen. I would like to make it clear. You do not mention any classes specifically regarding cell tower analysis, correct?
Considering that I have a master's in criminal justice, which covers a bit of cell tower analysis, I have taken classes.
Question. Do you mention specifically any classes you have taken in regards to cell tower analysis? Yes or no?
Objection, Your Honor. Relevance. The witness has already testified to the extent of his education, and asking of specific classes he has taken is not relevant.
Response, Your Honor. The witness has not answered my question as to whether or not they have specifically taken classes in regards to cell tower analysis. I requested a yes or no answer from him, and he has not complied.
Response, Your Honor.
And no response this time. I do agree that the witness has been quite dodgy with the question. And at this point, I'm going to instruct the witness to answer the question with a yes or no statement. The objection will be overruled. You may re-ask the question.
Thank you, Your Honor. Once again, Mr. Van Owen, you do not specifically mention classes in regards to cell tower analysis, correct?
This is not in my witness statement, no.
Furthermore, Mr. Van Owen, you don't mention the names of any specific cases and you've worked on in regards to cell tower analysis?
I have applied cell tower analysis in many of my cases and testified as an expert 5 times.
Right, but you don't mention any specific cases?
There were 5 specific cases that I was accepted as an expert in.
And you don't name any of them?
There's no need to name them, no. Not relevant in this case.
On this topic of cases, Mr. Van Owen, you were admitted as an expert in cell tower analysis for 5 cases, correct?
Yes.
And you have worked on over 100 cases, correct?
That's correct.
So you've only been admitted as an expert in under 5% of the cases you have worked on, correct?
As of now, only 5 of those cases required me to testify as an expert in that field, although I have applied my knowledge in that field in terms of the analysis more than that.
Your Honor, pursuant to Rule 702, Mr. Van Owen lacks the education, knowledge, training, skill, and expertise and cannot attest to any cell tower analysis as it is outside the scope of their expertise.
All right, so to clarify, your objection is only to the qualification in cell tower analysis. There's no objection to crime scene reconstruction or general police techniques?
No, Your Honor.
All right, your response then to the objection to qualifying him as an expert in cell tower analysis.
Your Honor, pursuant to Rule 702, a witness can be tendered in an expertise on the basis of knowledge, skill, experience, training, or education. Professor Van Owen has testified to extensive education and experience in the area of cell tower analysis. In addition, this is to be given to the weight of the opinion given, not to the ability to give the opinion.
Response, Your Honor.
Further response?
Mr. Van Owen has testified that he took a master's he has gotten a master's degree in criminal justice that has no application to cell tower analysis, and thus he has no education in regards to cell tower analysis, which is what counsel has based his entire expertise upon.
Response, Your Honor.
Briefly.
Your Honor, the witness has also testified to his experience as an expert in cell tower analysis. As he earlier testified, he has been accepted as an expert 5 times in the field of cell tower analysis, which falls under experience in pursuant to Rule 702.
Response, Your Honor.
No, at this point, I am going to tender him as an expert in all three proposed areas. But certainly if anything goes too far, please raise your objection at that time.
Thank you, Your Honor.
Now, Professor, let's talk about your relation to today's case. Now, what evidence did you look at during your evaluation?
For my evaluation, I like to start at the crime scene itself. So I viewed the crime scene photos, the crime scene reconstruction, any information from Detective Markowitz, as well as the autopsy report.
Now, what did you notice during your evaluation?
Throughout my evaluation, I noticed three fundamental issues with this case.
What's the first issue?
The first issue is the lack of certainty regarding the prosecution's claimed stabbing method.
The second?
The second is the scientific inaccuracy in terms of placing Miss Becker's location at the scene of the crime.
And Professor, what is the third?
The third and final issue is that in a general sense, this investigation is methodologically unsound.
Now, Professor, let's start with that first issue about the lack of evidentiary support for the stabbing method. Now, what evidence are you referring to?
In this particular instance, I am referring to the Ring doorbell videos, the crime scene photos, and the murder weapon itself.
Now, let's start with the Ring doorbell videos. Now, what did you notice during your review of these?
I reviewed the first and the third Ring doorbell videos in order to come to this conclusion. The first depicted an intruder of smaller size relative to Mr. Brackman himself, a rather large man, which would make it very challenging for that smaller intruder to actually engage and win a altercation between them and Mr. Brackman.
And now, how do the photos of the crime scene support this?
The photos of the crime scene support this when they're put in conjunction with the autopsy report.
And how does the autopsy report work in conjunction to that?
Taking the two together, we see Mr. Brackman in those crime scene photos laying on the ground with a wound in his upper left scapula. The autopsy report details that the knife was inserted down and toward the aorta, nicking that aorta through the scapula.
And how do we see this in the crime scene photos?
Taking another look at those photos, we see limited evidence of a struggle, and that evidence is completely unvalidated considering those scuff marks. And when you finally build a picture together, it's clear that Mr. Brackman was caught unaware by the intruder and the knife was inserted as such.
And now, how is this different than the prosecution's conclusion?
The prosecution, Ms. Cusack in particular, claims that Mr. Brackman was alerted to the intruder. However, upon viewing the third Ring doorbell video, we know this to be untrue.
Now, Professor, let's move on to the second issue, Ms. Becker's location on the cell tower diagrams. Now, did you review these diagrams?
Yes, I did.
Now, let's take a look at them. Ms. Karras, would you please screen share Exhibit 16? And now, Professor, what did you notice of your review of these diagrams?
Looking at these diagrams, the first thing I noticed were those three different towers and thus three different sectors that were activated by Ms. Becker's cell phone.
What did you notice about the sectors?
Those sectors, and those are those red areas you see there, are attempting to pinpoint Ms. Becker's location. However, scientifically, they cannot do that.
Why can't they do that?
Were you to extrapolate the area of those sectors using the radius of the area between the cell towers themselves, you would find that that red encompassing shader covers 37.7 square miles, which is far from a pinpointed location.
And now, what do these sectors say about Ms. Becker's location?
They say relatively little, considering that her phone could have been at her house and connected to all three of those cell towers in succession, depending on the traffic.
Ms. Karras, would you please stop screen sharing? Thank you. Now, Professor, let's move on to the third issue, that the investigation was methodologically unsound. Now, what made it unsound?
What made it so unsound was the lack of evidence gathered and the lack of investigation into further suspects.
What evidence did the prosecution fail to gather?
Taking a look at Detective Markowitz, we can see those text messages from Cifuentes were received as mere screenshots, even though she had the tools at her fingertips to gather true and clear depictions of those texts by downloading the contents of Ms. Cifuentes' phone using Cellbrite.
And now, Professor, is it standard police practice to just accept screenshots?
Certainly not. As an expert in general police investigation tactics and someone who's worked on the police force themselves, I can tell you that if this investigation were to be carried out thoroughly, Detective Markowitz could have simply gone to Ms. Cifuentes' house, asked for that phone to be produced, and downloaded the contents within mere minutes.
Now, Professor, did the prosecution fail to gather any other evidence?
The prosecution also failed to gather evidence regarding the Ring doorbell notifications for Mr. Brackman.
What would we have known if she had collected the Ring doorbell notifications?
If Detective Markowitz would have gathered these notification information through a production of a records request from the company of Ring, we would know whether or not Mr. Brackman could have been alerted to the intruder and thus would have had a clear picture of the crime.
Right. And now you mentioned alternate suspects. Did the prosecution investigate any other suspects?
Although identifying her as a possible suspect, they did not investigate a Blair Rollins.
Who was Blair Rollins?
Blair Rollins is the daughter of a Jonathan Rollins who is serving a life sentence in jail.
And what is the significance of that?
At first, it doesn't seem significant until you realize that Mr. Brackman represented Jonathan Rollins in that case.
And now what does that have to do with Blair Rollins?
Connecting back to why we are here today, it seems that Blair Rollins presents clear motive in this case that warranted investigation.
Now, did you do a further investigation into Blair Rollins?
I conducted a partial investigation, yes.
What did you find in that partial investigation?
First, I looked at the yearbook photos of Rollins and Becker and confirmed that they were of the same size and build. And then I conducted a search using standard investigative practices and online research in an attempt to locate Rollins, but I was unable to do so.
Now, did you find anything about Miss Rollins' location on the day of the crime?
On the day of the crime, using attendance records from the school, I found that Rollins was absent, which means that she could have committed that crime.
Now, Professor, do you have an expert opinion in this case?
I do, yes.
And what would that be?
In my expert opinion, across all my fields of expertise, this investigation was rushed and missed police work 101.
How so?
The prosecution had the tools at their fingertips to gather necessary evidence to actually have a valid conclusion, yet neglected to do so. They also neglected to investigate a clear suspect who had motive in this case, but instead chose the easy conclusion. Now, these errors could have led to incorrect conclusions as well, which is not true justice.
Thank you, Your Honor. No further questions at this time.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Thank you. Now, Mr. Van Owen, I'd like to establish a couple of things before we move on. You never went to the crime scene, correct?
Although I am a private investigator, ultimately I'm still a civilian, which means I do not have access to cordon-off crime scenes.
You never handled any of the evidence.
Similarly to that last question, as a civilian, I don't have access to evidence and lockup.
You never spoke to Avery Becker?
I did not. Her affidavit was sufficient.
You never spoke to Taylor Perkins?
Similarly to Ms. Becker, they were both under oath under the creation of that affidavit, and thus it was more than sufficient to learn the story.
Never spoke to Detective Markowitz?
I'm not entirely sure that Markowitz would want to speak to me.
You never spoke to Miss Kuzak?
I did not, no.
And you never spoke to Alex Cifuentes?
It seems you may be misinterpreting my occupation. My job is not to speak to suspects
Thank you, Mr.
or the
Van
police
Owen.
in this
You
case.
did not speak to Alex Cifuentes, correct?
Considering it's far outside of my job, as someone who analyzes an investigation, I did not.
Now I'd like to move on. You have never testified for the prosecution, is this correct?
I have not, no.
And you are getting paid to testify in this case, correct?
Just as you are being paid to do your job, I'm being paid to do mine.
Are we back?
Your Honor,
Right.
I believe I am back. I don't know if everybody else is.
I don't think so. So let's give it a second.
We're checking. I'm so sorry. Zoom crashed. I'm attempting to let everybody back in.
Perfect. I'm going to assume we stop time for a moment.
So sorry.
Yes, Your Honor, I stopped time. However, I think I was a few seconds late in stopping time, so we are checking right now what the other timer has.
Perfect. Makes me feel better this happens in real virtual court too.
Yes, it does. So sorry.
All the time. As trial attorneys, it's tough.
Oh yeah.
Your Honor, timers are having a bit of difficulty finding what time to go off of. I have 9 minutes at the moment.
Yeah, I didn't know if my video was the only one that froze, so I kept timing, so I'm off by kind of a lot.
Okay,
so
what's the discrepancy?
About like 40 seconds.
Okay, so did you stop the time right when the video froze?
No, I stopped it when it became clear that everyone else's video also like crashed.
Okay, and Ms. Gamber?
Your Honor, I stopped time similar when I found out, but I think I stopped it before her.
All right, do we have attorneys for either team? Do you either of you have a preference on how to handle this, the time discrepancy?
No, Your Honor, I have no preference.
No, Your Honor, I have no preference either. I'm fine with whatever we decide.
Given that the video froze and I don't totally know how much we lost there, are you all right with doing the longer amount of time? Just given I'm not quite sure when everyone fell off.
I think the longer amount of time is probably appropriate.
Perfect. All right, then we'll do that. If you two timekeepers want to confer and just do the higher time, then we'll do that. Thank you. Thanks for bringing it to my attention.
Thank you, Your Honor.
All right. Do we have all our jurors back on the line? I see one,
Yes, Your Honor.
2.
Yes, this is Miss Ray. I'm here.
And 3. All right. And are parties ready to continue where we left off?
Yes, Your Honor, the prosecution is ready to proceed.
Fantastic. All right. Proceed when you're ready.
Thank you, Your Honor. Now, I believe I stopped at my question. Mr. Van Owen, you mentioned that you have been paid just under $7,000 for this trial, correct?
That's the current rate I've charged, yes.
And you are paid $225 per hour?
For my research and analysis section, I am.
Your Honor, I ask the court to make judicial notice pursuant to Rule 201 of the fact that 7,000 divided by 225 is just above 31.
That shall be noted.
Thank you, Your Honor. Now, Mr. Van Owen, this means that you only worked 31 hours on this case, correct?
31 hours is a large amount of time to devote to the analysis and interpretation of evidence.
So you believe that less than a day and a half of working on one case is sufficient?
It's funny that you put it that way because 31 hours is near a full work week, which is more than enough to analyze this specific case.
Thank you, Mr. Van Owen. I'd like to move on. Now, you testified about Blair Rowlands, correct?
I did, yes.
And you talk about how Blair Rowlands and Avery Becker had the same general height and build?
That's true.
Now, Mr. Van Owen, I'm assuming you've seen pictures of the two of them together.
As I had stated, I reviewed the yearbook photos of the two.
So those pictures were of Blair and Avery standing next to each other?
They were not, no.
Thank you. Now, furthermore, you talk about the court recording that features Blair Rollins' father, correct?
There were a couple of
Objection, Your Honor. Improper impeachment pursuant to Rule 613A. Counsel is not to refer to the witness using their statement as a quote.
Response.
I'm sorry, counsel, which quote were you talking about?
Your Honor, I was referring to the quote. Now, you talked about a court recording in here, which would be quoting the witness's affidavit.
Response, Your Honor?
Respond.
I was, pardon me, no response, Your Honor. I can rephrase the question.
Certainly, I will sustain the objection. Rephrase the question.
Thank you. Now, Mr. Van Owen, you have heard the court recording that features Blair Rollins' father, correct?
I have heard numerous recordings of Mr. Rollins, yes.
The one I'm mentioning is the court recording that features Blair Rollins' father just after he was being sentenced to life in prison. I wanted to make that clear. Now, timekeeper, would you please pull up what has been marked as Exhibit 19? Or excuse me, Exhibit 22.
I'll get you back, Brackman, if it's the last thing I do.
Thank you. Now, Mr. Van Owen, do you recognize this?
Yes, I do.
And this is that recording that I was talking about that features Blair Rollins' father, correct?
Correct.
And am I correct in saying that that Blair Rollins' father, Jonathan Rollins, says here, "I'll get you back, Brackman," correct?
Including saying if it's the last thing I do.
Now, yes. Now, you believed earlier that Jonathan Rollins said that Mr. Brackman was going to die, correct?
It's not exactly what he said, but considering the context of this recording, it's pretty clear that was the intention.
So you believe getting someone back and someone dying is the exact same thing?
Within this context.
Objection, Your Honor.
Absolutely.
Relevance.
Response, relevance.
Your Honor, this goes to the witness's credibility as they believed that, excuse me, as they failed to differentiate someone getting someone back and someone dying. And I wanted to make that clear.
Response, Your Honor.
Okay.
Your Honor, the witness's inference of what this threat made in a courtroom means makes no fact in this case more or less probable and is not relevant.
I believe the assertion was this is going to the witness's credibility, and credibility is always at issue. So at this time, I'm going to overrule the objection. If it goes too far, though, please feel free to renew.
Yes, Your Honor.
May I re-ask the question, Your Honor?
You may.
Mr. Van Owen, you believe getting someone back and someone dying is the exact same thing, correct?
Within this context, it's clear Jonathan Rollins meant in getting Brackman back, it would be a sort of eye for an eye kind of thing. Since Rollins lost his life,
Thank you, Mr.
when he
Van
got sentenced to
Owen.
life in
That will be
prison,
all.
it's clear he
Objection,
ended
Your
Mr.
Honor.
Brackman's life.
Yes.
Your Honor, would you please instruct counsel to let the witness finish answering the question?
I've got a little bit of a problem here in that both sides have been doing this all day. At this point, as everyone's doing, I'm going to allow it at this time. If it gets too much worse, renew, but at this time I'm going to overrule.
Yes, Your Honor.
Your Honor, may I re-ask the question one more time?
Wait.
Mr. Van Owen, I would like a yes or no answer, please. You believe someone getting someone back and someone dying is the same thing, yes or no?
Unfortunately, this cannot be dwindled down to a yes or no answer because you have to understand the greater context of the quote from Jonathan Rollins in order to apply it to his true beliefs.
Right. Thank you, Mr. Van Owen. No further questions, Your Honor.
All right. Redirect examination?
No redirect examination necessary, Your Honor.
And you may call your next witness.
Your Honor, before the defense calls its next witness, I'd like to request a brief time check.
Certainly.
Yes, at the moment you have 7 minutes and 48 seconds left.
Thank you. The defense calls its third and final witness, Ms. Avery Becker, to the stand, Your Honor.
You're ready.
Permission to proceed? Thank you, Your Honor. Good evening, Ms. Becker. Would you please introduce yourself to the jury?
Good evening. My name is Avery Becker.
Ms. Becker, why are you here today?
I shouldn't be here at all. The things they're accusing me of are just horrible to think about, and I get sick to my stomach just thinking about them.
Thank you. I'm going to start off asking you some questions about your high school experience. What high school did you go to?
I actually just graduated from Colorado High School. I should be in college right now, though.
Did you participate in any extracurricular activities there?
I was in mock trial for 4 years and I loved it.
Why did you decide to do mock trial?
Well, my friend Taylor and we decided to do it back in our freshman year, and it was just one of those things that sounded fun, and I realized I was pretty good at it, and I just wanted to do it for the rest of high school.
And you were at the Fry Shack, or excuse me, who was your mock trial coach?
That was Coach Brackman.
Would you mind explaining to the jury a little bit about what your relationship with Mr. Brackman looks like?
Well, I knew Coach Brackman for 4 years. That's a really long time to know someone, and we spent a lot of time together because of mock trial, and I looked up to him for a really long time. But we started to have these really stupid arguments in my senior year just over competition stuff, and I just can't believe that we were arguing so much before he passed.
Okay. I'm going to ask you a couple questions about that senior year. Would you mind describing to the jury the practice after your regional competition that year?
Yeah, so I just won a few awards for best. Actually, I only won one award for best attorney at regionals, and I was really excited because it's kind of a big deal, and I hoped Coach Brackman would be excited too, but instead we just ended up arguing again.
And how did this argument make you feel?
I felt horrible. I hated arguing with Coach Brackman, and I felt frustrated and powerless, and I just felt horrible.
And afterwards, what happened?
Well, I had a marker in my hand from writing at the whiteboard, and I had to leave the room. I just felt like I had to get some air, and I still had the marker in my hand, and I made the worst decision of my life, and I wrote on Coach Brackman's car.
And afterwards, what happened?
Well, Coach came out, I think, to talk to me about something, and he saw what I had done to his car, and we kind of realized the marker was permanent around the same time, and he was just so furious because he had a really nice car, and I felt terrible, and he kicked me off the team.
Did you do anything to try and make amends with Mr. Brackman?
I did everything I thought I could to make amends. I wanted to make amends with Coach Brackman so badly. I texted him. I offered to pay for the damages I had done. I even went to his office at the law firm he worked at to see if I could talk to him in person, but I couldn't get through to him. And then all of a sudden he was just gone.
Okay, thank you. Let's move on and talk about the events that took place on March 6th.
Mm-hmm.
Are you okay, Ms. Becker?
I am, yes, thank you.
Would you mind describing to the jury what happened on the morning of March 6th?
Well, I woke up and I couldn't find my phone anywhere, which I realized because my alarm for school hadn't gone off, and I just freaked out because phones are really expensive and I didn't want to have to go buy another one. So I went to my friend Taylor's house to see if she'd help me look for it.
Did she?
Yeah, Taylor's so sweet. She immediately offered to skip school with me and just help me look for it because we figured it wouldn't be a big deal if we missed a day of school.
Where did you and Ms. Perkins go to look?
Well, the day before we had gone to the mall, so that's where we started looking, and it ended up eating up the whole day because we just searched the entire mall from top to bottom.
Do you remember the last place that you had your phone?
Well, the last time I remember actually seeing my phone was at the Fry Shack the day before on March 5th near Alex Fuentes.
Were you ever able to find your phone?
No, and this is so unlike me. I usually have my phone with me like most teenagers, but Taylor and I were even calling it and we just couldn't hear it ring or anything like it was stolen or dead or something. I have no idea where it is.
And how long did you and Miss Perkins look?
We looked all day from morning until late in the evening because we took up so much time at the mall.
Okay. Now I'm going to ask you a couple questions about your relationships with other students. You mentioned Alex Fuentes earlier. Would you mind describing to the jury a little bit about what your relationship with her looked like?
Well, Alex and I were teammates, and we never specifically argued, but I just kind of got the feeling like she didn't like me very much.
Objection.
talk to Miss-
Ms. Becker can't testify to whether Alex Fuentes liked her or not, as she is not Alex Fuentes.
Response, Your Honor. Your Honor, as Mr. Fuentes and Ms. Becker were in mock trial together, they spent a lot of time together. So this is just a rationally based perception based on Ms. Becker.
Response, Your Honor. Just because Ms. Becker and Ms. Cifuentes were in mock trial together doesn't mean that Ms. Becker knew how Cifuentes felt towards her.
Response, Your Honor.
No, at this time I'm going to overrule and allow the witness to testify to what she knows and believes.
Yes, Your Honor. Ms. Becker, did you finish answering your question?
No, I don't think I did. Actually, I'm sorry, I did.
Did you talk to Ms. Fuentes very often?
No, in fact, I can't remember the last time I talked to Alex outside of mock trial.
Ms. Karras, would you please display Exhibit 14 on the screen, as it has already been entered into evidence? Ms. Becker, did you send these text messages?
No, those don't even look like messages I would ever send. I mean, I don't introduce myself like that at the start of texts, and I never knew where Coach Brackman lived, so I never would have said that I was going to his house.
Okay. Thank you, Ms. Karras. Now, Ms. Becker, I just have a couple more questions for you. Were you anywhere near Mr. Brackman's house on March 6th?
No, like I said, I didn't even know where Coach lived, and Taylor and I were at the mall all day searching for my phone.
And finally, Ms. Becker, did you commit these crimes?
I never, ever would have done what they're accusing me of. I just wanted to make amends with Coach Brackman. I didn't do this. I didn't do this.
Okay. Thank you, Ms. Becker. I know it can't be easy for you. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good evening, Ms. Becker. I'd like to start with your relationship with Mackenzie Brackman when you were on the mock trial team. You and him never quite got along, did you?
No, we just had all these stupid arguments, and I just can't believe we argued like that before he
And
passed.
it was your impression that he thought you were lazy, stuck up, and disruptive, correct?
I mean, I guess he said that to me at some point, yes.
He often criticized your work ethic.
Yeah, we disagreed sometimes over work ethic.
And even though you had won a big award at regionals, you thought he was angry at you the next practice because he believed your lack of work ethic would hurt the team at state, correct?
I mean, we did end up arguing about the awards, so I guess he was angry at me, yes.
So you got angry at him and wrote worst attorney award on his car and what you now say you thought was a dry erase marker?
Objection, Your Honor. Argumentative.
Response?
Your Honor, I would like to request clarification on which part of my question was argumentative.
Your Honor, Ms. Becker already testified that the marker she believed she was using was, in fact, not permanent. So asking the witness to testify to a marker that she believed was permanent was argumentative.
Response, Your Honor.
Okay.
Just because Ms. Becker has testified to something that she believed in a different examination doesn't mean she can't be asked a question about it in my cross-examination.
At this time, I'm going to overrule the objection and allow the witness to clarify that point if she needs to.
Would you like me to rephrase my question, Ms. Becker?
Yes, please.
You got angry at Mr. Brackman and wrote worst attorney award on his car in what you now say you thought was a dry erase marker, correct?
Well, I was pretty upset with the whole situation, and I did write on Coach Brackman's car, but I had no idea the marker was permanent until it was too late.
And once he saw what you had done to his car, he kicked you off the team, correct?
Yeah, he was really upset. It was a nice car.
So he kicked you off the team because you vandalized his property, correct?
He did, and I tried everything I could to make amends with him.
And once he kicked you off the team, you were upset, correct?
I was horrified at what happened. I mean, I couldn't believe that I wasn't in mock trial anymore. I loved mock trial.
You were angry?
I was. I was angry at myself and a little bit at coach until I realized I just needed to make amends with him.
Willing to get him back if it was the last thing you did?
You know, I said that to my mom, but I realized immediately after all I wanted to do was make amends with coach. I didn't mean what I said.
But you did say that, correct?
Before my mom calmed me down and made me realize all I needed to do was make amends, I did say that, but I didn't mean it.
Now, you say that you would never hurt Mr. Brackman or his property, correct?
I mean, other than the one mistake, I would never try to make that worse. I didn't want to make any of what I had done worse.
But you had already vandalized something of his, hadn't you?
I had, and I felt so terrible. All I wanted to do was make amends with coach.
And that was after he kicked you off the team, correct?
Yes, I wanted to make amends with him after that.
And this was more drastic, not just kicked off the team. This time, sorry, apologies, not just insulted. This time you were kicked off the team. Your mock trial career was over, wasn't it?
It was, for all I thought, yeah.
Finally, I'd like to talk about the location of your cell phone. Now, you claim that you lost your phone at the Fry Shack the day before the murder took place, correct?
I did lose my phone at the Fry Shack, I think. I don't know where it is exactly.
You claim it was likely dead or stolen?
I mean, that's what I would assume because I was unable to find it and Taylor and I couldn't hear it ring when we called it.
So you and Taylor Perkins tried calling your phone to look for it, correct?
Yeah, Taylor had her phone and we were just trying to hear it ring as we searched the mall.
Now, according to Detective Markowitz's previous expert testimony, your phone communicated with 3 cell towers near your house and Mackenzie Brackman's house right before the murder took place. But you claim you lost your phone the day before, correct?
I mean, I don't totally understand Detective Markowitz's whole thing. It's a little over my head, but that's what I've heard.
So around 24 hours had passed since you lost the phone and you and Taylor tried calling it, correct?
I guess so, yeah. I don't remember the specifics. I was so stressed out.
So you're saying that your phone, which had been stolen or lost for an entire day, happened to be moving around in between your house and Mr. Brackman's house without it being in your possession?
Well, I didn't have it. I don't know who else did, who was making it move around, but I did not have it with me.
But you heard Detective Markowitz's testimony, correct?
Well, I know my phone was moving around, but I don't know who was making it move around.
So you're saying, I can rephrase my question, you're saying that it's merely a coincidence that your phone was moving around in between your house and Mackenzie Brackman's house?
Well, I don't know because I didn't have my phone and I don't know who did.
Finally, you believe that Blair Rollins was somehow connected to the disappearance of your phone, correct?
You know, all I know is that I didn't do this, and I know that Blair had some sort of thing with his dad and Coach Brackman. I don't know because I'm not an investigator.
Becker, did you ever see Blair at the Fry Shack with your phone?
No, I didn't.
In fact, did you see Blair Rollins at the Fry Shack March 5th at all?
No, I don't believe I did.
So this is just your uncorroborated theory.
You know, all I know is that I didn't do it, and I'm not an investigator, so I don't know who actually did it, but I didn't do this.
But you don't have any evidence to support the claim that Blair was related to your phone, correct?
No, because I'm not an investigator. I don't have evidence.
Stop.
I have no further questions, Your Honor.
Direct examination.
No recross necessary, Your Honor.
This witness may be excused. Does the defense have any further witnesses?
The defense has no further witnesses, Your Honor, but before the defense rests, I'd like to confirm that exhibits 1 and 4 were entered into evidence by the defense.
Right. I didn't write down every single one. I do believe that's correct. However.
Yes, Your Honor. And the defense rests.
Right. Prosecution, you ready for closing argument?
Yes, Your Honor, and I would like to save any time I have remaining at the end of my closing argument for rebuttal.
Certainly. Begin when you are ready.
Ladies and gentlemen of the jury, do you know what happens when an unstoppable force meets an immovable object? Felony murder. That's what happens. Avery Becker, a high school kid whose idea of self-entitlement truly was unstoppable, met Mackenzie Brackman, a classic coach, determined to help his students his way. But why was Becker unstoppable? She's never really thought of herself as someone that society's limits apply to. from preparing for practice to listening to the advice of other people. She's always just done what she pleases. And in her mind, why should she follow the rules? Why should she do what the other kids do when she can just make it up on the spot and do better than them? All of this against the immovable object, Brackman. Deeply rooted in his ways, he was fully committed to helping his students the only way he knew how, and fully committed to being the best coach he could be. He always believed that if Avery was to truly be successful, she would need to learn how to work hard and prepare. So he tried to instill in her the best work ethic he could, but she just wouldn't listen. Now, there are 2 charges brought before you today that you must find Avery Becker guilty of. The first, felony murder, charges Becker with committing or attempting to commit second-degree burglary in the state of Colorado, and in doing so, killing Mackenzie Brackman, whether acting alone or with 1 or more persons. The second, second-degree burglary, charges Becker with unlawfully and knowingly entering and remaining in Mackenzie Brackman's dwelling in the state of Colorado with the intent to commit criminal mischief against his person or property. Let's start with second-degree burglary. Jury instruction number 8 required the prosecution to prove that Avery Becker went to Mackenzie Brackman's house with the intent to commit criminal mischief. Detective Jordan Markowitz and Alex Cifuentes proved this to be true. Detective Markowitz proved it by showing you text messages exchanged between Avery Becker and Alex Cifuentes, where Becker told Cifuentes she was going to trash Brackman's house. Alex Cifuentes proved it by testifying that Becker was angry after being kicked off the mock trial team and wanted to get back at Brackman for what he had done. Detective Markowitz also used her expertise of call detail records to corroborate the fact that Becker's phone was in the vicinity of Brackman's house at the time of the murder. Both Detective Jordan Markowitz and Alex Cifuentes proved that Becker went to Brackman's house with the intent to commit criminal mischief and thus committed second-degree burglary. Now on to felony murder. Jury instruction number 9 required the prosecution to prove that Avery Becker killed Brackman while committing second-degree burglary. Crime scene reconstruction expert Kyle Kuzak outlined the details of her investigation and recreation of the crime scene to you. She observed evidence like the broken plate and missing knife from the knife block to conclude that based on signs of a struggle, Mackenzie Brackman had interrupted a burglary and gotten fatally stabbed. Detective Markowitz and Alex Cifuentes proved that Becker was committing second-degree burglary, and Kyle Kuzak proved that Becker killed Brackman in the residence. Now, ladies and gentlemen of the jury, as you listen to the defense's closing argument, please keep one thing in mind. The evidence establishes that Avery Becker does what she thinks she deserves. If she was the best person at mock trial on her team, she thought she deserved to not prepare. If Mackenzie Brackman insulted her after winning a big award at regionals, she thought she deserved to trash his car. And if Brackman kicked her off the mock trial team and ruined her mock trial career, she thought she deserved vengeance. Jury instruction number 2 states that if you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt, you must find the defendant guilty of that crime. Today, the prosecution has clearly proven all elements of Avery Becker's charges beyond a reasonable doubt, so you must find her guilty. Thank you.
I was on mute. Closing argument for the defense.
Yes, Your Honor. Permission to proceed, Your Honor?
When you're ready, yes.
May it please the court. Your Honor, members of the jury, this is a case about how careless investigations lead to erroneous conclusions. And the prosecution brought 2 charges against Ms. Becker: murder in the first degree and second-degree burglary. Remember, the prosecution bears the burden of proof. They are obligated to prove every single element of the crimes charged beyond a reasonable doubt. That is a doubt that would make a reasonable person hesitate in matters of importance to themselves. The evidence and testimony you heard today shows that the prosecution failed to meet their burden and that Ms. Becker must be found not guilty. And the prosecution claims Avery Becker's here because the evidence points to her. But let's take a look at their evidence. They're fragmented, mismatched, sloppy evidence. Now we know Ms. Becker wasn't at school on March 6th. Ms. Becker testified to it because she has no reason to hide it. You heard Ms. Becker testify that on that morning she'd woken up and realized her phone was missing. So she skipped school and spent the entire day looking for it with Taylor Perkins. And you heard Ms. Perkins testify to the exact same thing. You heard her confirm that truth. The problem is that when the prosecution learned Ms. Becker wasn't at school on March 6th, they had already made up their minds. Yet that they also knew Blair Rollins, a viable suspect and the child of a disgruntled ex-client of Mr. Brackman's, wasn't at school that day either. They didn't follow that lead then, and they can't now. Why? Because Blair Rollins disappeared right after graduation, and to this day is nowhere to be found. Now let's start with Detective Markowitz, who got locked in with tunnel vision on one person from the very beginning. Detective Markowitz testified that she began her investigation looking into mock trial students. But how many students did Detective Markowitz investigate before she locked in on Ms. Becker? 1. After interviewing that one student, Detective Markowitz decided she didn't need to keep looking, keep investigating. In fact, the only thing Detective Markowitz looked at were screenshots of a text conversation. Detective Markowitz didn't find it necessary to provide any means of authentication on these screenshots, but rather took the word of the one student she interviewed without a second thought. The student was Alex Cifuentes, the same Alex Cifuentes who saw Avery Becker's success as a slap in the face, the same Alex Cifuentes who just so happens to be the last person seen in possession of Miss Becker's phone. None of that mattered to Detective Markowitz. Didn't raise any concerns in her mind because she found her convenient conclusion. She never looked back. It only takes one hole to sink the prosecution's entire case, but Professor Van Owen provided many, like the inability of the prosecution to pinpoint Miss Becker's location with absolute certainty. Still, the prosecution attempted to justify their erroneous conclusion with another careless investigation. You heard the prosecution's crime scene reconstructionist, Ms. Kuzak, claim that her investigation was thorough, but no amount of flowcharts and spreadsheets can hide two very important things. One, that during her investigation, Ms. Kuzak failed to acknowledge that the pictures displaying Mr. Brackman's body, the pictures she analyzed, depicted varying body positions. And two, that Ms. Kuzak failed to take vital observations like a wedding ring on Mr. Brackman's hand into consideration. And Ms. Kuzak is not in the business where sloppy work is ever acceptable, and yet here we are as a direct result of her sloppy work. After the countless paths leading them elsewhere, the prosecution still decided it should be Avery Becker who sits here today. Why? Well, for two reasons. Because the prosecution cherry-picked the evidence they wanted to examine, and because they predetermined the path of least resistance. Members of the jury, there are too many loose threads, too many unanswered questions for Miss Becker to be convicted of the alleged crimes. It is wrong to send an innocent person to jail. But sending an innocent person to jail based on rushed investigations and inconclusive evidence, that is unjust. And there's been enough injustice in this case as the prosecution arrived at their erroneous conclusion after favoring what is convenient over what is true. As the prosecution failed to meet their burden of proof, the defense asks you to find Avery Becker not guilty. Thank you.
Prosecution rebuttal.
May I proceed, Your Honor?
You may.
Ladies and gentlemen of the jury, opposing counsel stated that Detective Markowitz's investigation was flawed because she only investigated Avery Becker. There was a reason that Detective Markowitz only investigated one suspect. Because the evidence against that suspect, against Avery Becker, was so damning and Detective Markowitz was able to reach such a clear conclusion from that evidence that she didn't need to investigate any other suspects. Thank you.
All right. Congratulations. Any further matters from either side? Okay. So,
Not from the prosecution, Your Honor.
all right. Well done, everyone. I think what we're going to do now is give people a chance give the jurors a chance to fill out their score sheets. What I'm going to do in the meantime while I do that is I'm not going to give you any feedback, but I'm going to take these couple seconds just to tell you guys a couple of fun stories. So I'll introduce myself though while I fill it out. My name is Kelsey Madden. I am with the Denver District Attorney's Office. I am a deputy district attorney. Yeah, feel free to turn on your cameras or not, whatever you want to do. So I obviously do a lot of trials as a DA, not so much now, but typically we'd be in this position a lot. I competed in a mock trial for about 11 years. That was high school, college, law school. I've coached teams. I've been in your exact position. But virtual mock trial is a little weird. So I'm living that virtual court life every day, and I know it's tricky. But a couple of things I want to tell you here before we get moving are, first, when you entered that exhibit of the victim, I may have looked like I was laughing, and it's because that's a picture of my dad. That's Judge Madden. He's the one in there, and I just couldn't help but laugh. It was just, he made me buy him fake blood one day and didn't tell me why. Also, if you did the problem last year, this is Pepper Marie Clementine. She was that's her real name. So she was in the problem last year.
Hey,
so
Pepper.
Obviously, I'm very related to the mock trial program, and I'm happy to be here. So,
your score sheets are all in, Judge Madden.
Judge Madden is my father.
I know, it's hard for me.
Please. Yeah, no, that feels weird being called Judge Madden. So what I'm going to do here is I'm just going to give you guys a couple kind of general comments here. If you let me talk about everything I wrote down, we'll be here all night. So let's not do that. First, I want to say you guys are great. I know being virtual is weird. I don't think any of us have totally figured out the best way to do it. I thought you guys did great. I thought the objections were great. Very good responses. I thought the questions were very thoughtful, some very good tone, and a lot of great confidence, given the kind of weird situation. The couple things I want to bring up quickly. I saw every single person cut off a witness at one point, and I let that go just because everyone was doing it. If you do that in the real world, you are going to get your head chewed off by 1, your judge, 2, the court reporter if you have one. I've been snapped out for it. I think everyone has it happen at some point in the courtroom, and it sucks. I was told not to do it all throughout mock trial, and I still did it in a courtroom one day, and it did not go well for me. So that one always makes me cringe, because once you get yelled at for it, you get really, really careful about not doing it. For objections, I don't know your case as well as you do. I've got the rules of evidence down pretty well, hopefully. But if you guys can frame sort of the facts a little better, explain to me more, here's why we're objecting. I got a lot of rules, but I would just a little bit more relating to, here's what the witness said, here's why that doesn't fit the rule. Because sometimes I've heard the question and I'm not listening to the question with your mindset, and having you say, this is what the question was, this is what the answer was, a little more related to the rules can really help. The other thing I'd say is, don't ask for a response every single time you have an objection. I'm going to give you time to respond, or if I don't want a response, I don't want a response. But unless it's dire and you really have something to add and I'm not going to give you a response, I wouldn't ask for it. I'll get it for you. And it just made things a little bit confusing. And the last thing you want to do is talk yourself out of my ruling. Now for witnesses, I thought there were some great characters here. I wish my witnesses were this prepared. The other thing though is, what I want to point out, given this sort of situation, is usually you guys can add some flair in how you walk to the stand or how you look at an exhibit or what you're doing. And it's a little harder to pick up on that. I picked up on a lot of tone and answers and things like that, but I wouldn't be afraid to move a little bit more in your seat. That may be leaning forward or leaning back or taking a posture that's not so straight up and down, so I can see some more of that character come out. Overall, I obviously thought you guys did great. I'm going to put my email in the chat here. And feel free to email me if you want questions. Coaches, same for you. If you don't want feedback, I'm not offended. Don't email me. But if you do want to, it'll be in the chat. And I'll turn over to our jurors.
Okay. Well, I guess I'll go first. My name is Julia Morgenthau. I'm an attorney, and I've been an attorney for, gosh, 12 years now in trial, and so I have quite a bit of experience there. I was very impressed with how everyone presented their case. It was clear that you all knew the material very well. I thought your knowledge of the rules of evidence was particularly good. I have judged some of the competition earlier, 3 or 4 weeks back, and I must admit that I just was really impressed by your grasp of the rules of evidence. And I want you to know that that is not something that's easy. So I'm really impressed by that. I'd like to call out one person in particular. I really thought that Haley Carras had an excellent cross-examination, and I was just very impressed by her, and I was impressed by all of you, but I just had to do that call out. As far as constructive criticism, the only thing I would say is I agree with Judge Madden saying that that interrupting a witness is not allowed in court. And actually, not only will it anger the judge, but the jury usually doesn't like you after because they think that you are being rude or toward the witness. So, and obviously in mock trial, you're under different circumstances because you want to get your case in, and when you let the witness go off on a tangent, they're taking up your time. So I'm not begrudging you that, but I would just mention that redirect is the proper area to allow your witness to explain themselves. So what you do is when your witness is being cross-examined, have your pen ready, jot down notes. Whenever your witness is like, yes, but, jot the note down, and you probably know what they're trying to say or what they're trying to explain. Then on redirect examination, you get up and you say, why don't you now tell us what it was you were going to say there? And I thought that there were a couple opportunities where, the person giving the direct examination did not ask for any redirect. And to me, those are missed opportunities, because even if you just ask 1 or 2 questions, remember, you're steering the ship back to the points you think are most important, right? And obviously people's memories are freshest with the last questions they heard. So my only suggestion there would be use your redirect, and very good job. I think you guys could all have been in a courtroom. So nice.
I'll go ahead and go next if that's okay, Nicholas. Is that all right? Okay, great. So my name is Diana Ray. I've been a litigator for 9 years. And I also coached mock trial for years. So I had kids though of my own. And so I kind of stopped that. So now I am scoring and judging, which is great. But I just want to say, wow, you guys did really good. I just want to say, I mean, I have seen these, I have seen tournaments, and you guys did really good. I want to do some honorable mentions, and then I do want to do a little bit of constructive criticism. I just want to say the back and forth between Bo and Lily on those objections and responses. I forgot I was watching mock trial. Like, I thought I was watching a real trial, and actually probably better than a lot of the attorneys I litigate against. Like, you guys were just like, boom, 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 boom. And I was like, yes, that's what I want to see. That's what I want to hear. That's what being an attorney is all about. And I just loved it. I absolutely loved it. I just want to say that. I mean, that was so good. And also Chloe as a witness, great job. Really good job. Like, you kept, like, a lot of times you can keep the acting on direct, but once you get to cross, you all of a sudden get really, you can get really defensive, and you kept it out throughout the whole, that little innocent cry, great. I mean, it was really, really good. And so, but I thought you all did a really good job with your objections. I will say to go from kind of like a 9 to a 10 is just what Kelsey said. I didn't say Judge Madden. See, I did that for you. Is that to make sure that when you object or you're responding to the objection, that you kind of have an objective sandwich, which is you cite the rule number, what the rule says, and the fact that goes with the rule. So, objection, hearsay. When you object, you don't really have to necessarily, but you can say, I object to the statement of blank, and then your opposing counsel can say, okay, I respond, it is not hearsay. Because of 803, whatever and Bo, you did a good job on a few of those, but even explaining a little more because 803 says this and the fact and the statement says this, right? Just going into a little bit more detail, and it just brings you up even more. I will also say, the redirect, I completely agree. And I'm sorry, I lost it, but the other scoring judge, you want to have the last say. Every attorney, I mean, we can't stop talking, right? I mean, judges are usually like, Miss Ray, that's good, right? Because I want to get the last say in. I want the jury or the judge to know that I'm the one controlling the show, right? That this is what is happening. And so redirect is a great opportunity to do that, to get that last say in there. The other thing, and I think this is really difficult, and I think this is difficult for some attorneys is openings, right? So openings, I felt I didn't get the elements from the prosecution in your opening of, what you needed to prove. I did hear the burden, which is good, but I didn't hear the elements. And then what you want to do is you want to set it's a roadmap, right? You're going to tell us, it's a table of contents. This is what you're going to hear today, ladies and gentlemen of the jury. This is what we're going to show you. This is what we're going to prove. This is what you're going to hear. Instead of being argumentative that this is what's happened, this is what you're going to hear. This is what I want you to look out for, right? That's kind of thing. I want you to look out for Avery's behavior, that kind of thing. So then it shows us as a jury, we can kind of jot down, oh yeah, that's what I wanted. That's what I need to look for. Instead of argumentative, that's for closing. And I think the two closers did a phenomenal job doing that in closing. And I do want to say, Bo, great job using the elements. That's the first time in this competition at the regional level, of the state level, that I heard the elements and the facts that prove the elements and the burden of proof. So I just wanted to say, great job on the closing. Openings are tough, and I get that, but I think a little bit work on the openings would be great. Okay, I'm done.
Hello, everyone. My name is Nick Shine. I am a law student, actually, a 3L at DU. So I have nowhere near the experience that everyone else here does. Moreover, I want to be a patent attorney. So trial is not my forte. With that said, you blew me away. I cannot believe it. I have not participated in real trials, but I've seen many live trials and have witnessed mock trials and have participated in oral arguments. And I'm blown away by what I saw today. I couldn't believe that you all are high school students, I think, right? High school students. Amazing. For me, it came down to 1 point difference. I really thought that both teams did a phenomenal job. I want to just second everything that Judge Madden said and the other two jurors said. And I wanted to point out that I thought that, Carolyn, your closing argument was really well done. You could just tell that you were so well prepared for it. And it seemed so natural. And that is just huge. Knowing the material in and out, every single step, every single piece of it is crucial. And I think that you did a really good job with that. And I think that you all did a really good job with that. And with that, I'll just stand back in awe. Again, I'm thoroughly impressed.
So I've been told our score sheets are good. So everyone is free to go. Please go eat dinner, sleep.
Great job, you guys. Seriously.
Tomorrow morning.
Good job. Awesome.
Thank you.
Awesome.
Thank you.
Thank you so much, Your Honor.
Thank you, Your Honor,
much.
and jury members, thank
Thank
you for your
you.
time and attention. Thank you.